topic. So now we've got our recording turned on. Just wanted to remind everyone today that I encourage you to please turn your microphones off. I can mute you out, but then I'm not sure if that will allow, so mute yourself out. And that's just so that in case there's some background noise in your office or some echoing or something that goes on, it usually makes things run a little bit more smoothly. But I would really, really like you to, if you have a question at any point in time or a comment during the presentation, please unmute your microphone, jump right in and introduce yourself and ask your question. Just interrupt me. We're not in a live room, and some of you have heard me say this before, but in a live room, I can sense body language and facial expression. People stick their hand up and talk out, and it's very interactive. It's difficult when we are in a session like this to be interactive. And we got a lot to get through, so we can't necessarily do a lot of breakout sessions and that sort of thing. But I do encourage you to interrupt and ask questions whenever you have one. Again, I want to thank everyone for attending today. This is the third CPC, I think third CPC course in this session. I'm going to take 2 seconds to share my screen and find that presentation and get her loaded up for you. Again, today's session is on business practices and ethics. There's a bunch of things at the beginning of this presentation that for most of you, I think pretty much everyone on today has been through at least one of the sessions, most of you two of the sessions so far. So you'll recognize some of these first screens because they're pretty standard. The certified personnel consultant is the only recognized certified professional designation in the recruitment industry in Canada. It's run by and organized through ACSESS, again, the only industry association exclusively representing the interests of the recruitment and staffing services industry in the country, focused on things like training and certification, business practices and ethics, legal issues, and particularly lobbying and influencing public policy and legislation, and in turn, also educating our members to make sure that we're up to speed on that. So far, for those people who've been with me in the last 2 sessions, have been legal aspects of staffing and legal aspects of recruitment. And today we're going to be talking about business practices and ethics. Later on in the fall, you'll have the opportunity to also add on an extra bonus session on sales. And I encourage everybody who's completed their CPC to also join that session. And of course, there's the CPC exam, the challenge exam that occurs at the end of these 5 sessions. Then it'll again be offered again later in the fall, probably in about November. The exam will be offered again then. It's a multiple guest format. And I remind everyone that it's not important that you memorize all of the specific details, but it is important that you recognize what the topics are, some of the general principles around those topics, and where you can find, whether it's legislation, regulation, provincial, federal, policy, best practice that you can get from the corporate web, from the ACSESS website, where you can find the answers to that. Because things change and every province is a little bit different and the federal government's a little bit different. So knowing what you should know is more important than actually memorizing all the details on a minute-to-minute, day-to-day basis. But of course, knowing it really well is important. So you don't have to go looking up these things all the time, and you just do things naturally and professionally. Today, I'll do this at the beginning. Also, before we get started, sorry, forgot to do that. Today, I also want to remind people that if you do not have a member login into the ACSESS website, the member services area of the ACSESS website, then I encourage you to send an email to Jennifer Trayer at the office, who's helped you get organized for this, and ask for a membership, and she'll associate you to the member company that you work for And a lot of the things that we're going to talk about today, there are documents and resources that can be found on the ACSESS website to support that, particularly on the best practices area. So today we're going to talk about business practices and ethics. We're going to talk about the code of ethics and standards that exist for ACSESS. We're talking about some industry practices, and we're going to talk about some recommended methods in order to handle some things as we go through this. And I just wanted to basically say that in my experience, remember, I'm old. I've been around this business since 1983. I've seen companies come and go. I've seen new companies grow into behemoths, and I've seen old companies fail and disappear or merge and get acquired. People retire, independent operators, and huge conglomerates changing over the years. But the one thing, I think maybe the two things that have really contributed to different companies' success in Canada over the years has been one, the uniqueness of the business that they provide. So do they specialize or have a methodology or a technology or a vertical types of jobs that they work in, or certain industries that they specialize in? And even big companies tend to break themselves down into verticals or specialty areas so that the IT folks are dealing with IT folks and the office folks are dealing with office and accounting with accounting and so on. So having that sort of area of specialization has been really important to people's success. But the other thing that is common across the board is ethics. Companies and candidates want to do business with people that they trust. They want to know that their data is secure, they're being treated with dignity and respect, that they're being treated honestly, that they're not being taken advantage of, that they're being treated fairly. And both companies, our customers, want to know that the organizations representing them to bring people into their organization are living at a high standard and operating at a high standard that represent them well. And people who are looking for jobs and putting trust in a third party to represent their confidentiality and their careers and their livelihood are also going to treat them professionally and respectfully. So I've always said to people, if you don't have anything super special about your company that you can differentiate from all the rest, you can always talk about things like ethics and safety, because those two things never get old. So the ACSESS mission statement is to promote and interest the growth of the Canadian recruitment and staffing industry. In order to accomplish this, ACSESS will identify and communicate, monitor industry standards, to positively influence and protect regulatory and business environment for our members, to promote our credibility and visibility of the industry to the business community, the governments, the candidates, and the general public, to provide our members with strategic support. And we're going to talk about that today because I'm going to show you some resources that are available. Strategic support services, programs, and tools to assist with achieving these goals. So, what is ethics? I mean, everybody seems I don't know if everyone has a different definition. I don't know if everyone has a different definition of ethics, but I think that different people have different standards with respect to their ethics. And so first off, let's just deal with a dictionary kind of definition known as a moral philosophy. It's a branch of philosophy which seeks to address questions about morality, that is, about concepts such as good and bad, right and wrong, justice and virtue. And very often, when a business talks about its ethical business practices, they really are only talking about their adherence to legislation and regulation. So, when you're not to disparage financial investment companies, those people that help people do their financial planning. But, they all talk about ethics. And I've been on the board of a couple of financial management companies for years. And it's kind of interesting when you go to a board meeting, the talk is all about compliance with regulations and standards set by either the government or by their regulatory bodies, not about what's right or wrong, not about what's honest or dishonest, not about what is moral or immoral, but what is compliant. And so, you always hear about a compliance officer. And so when we talk about ethics, we go one step, I think many steps, sometimes many steps, beyond just our obligation to be compliant with the law. So to say that we've never been convicted of a criminal offense before doesn't necessarily differentiate anyone, most people, on an ethical standpoint. But we hear it described in different terms. People talk about their beliefs or their corporate culture or their values or what they want in their suppliers and in their employees using different words. And we talk about honesty and concern for others and integrity and fairness, accountability, doing what we say we're going to do and holding ourselves accountable and responsible for the outcomes. Sometimes we think about leadership as a part of the subset of ethics. Giving respect to others, being respectful of others is a subset of ethics. Promise keeping and promise making. There's always the implied promise keeping, but real promise keepers or promise makers, they say what they promise to people, and then they keep their promises. And so real promise keeping comes from promise makers. Loyalty. So, I suppose, you could belong to a street gang that does really bad things and be loyal to your leader. So loyalty can go both ways. But when it comes to having trust in people that you give a fiduciary duty to, that you honor other people with your trust in them to look after something on your behalf, or someone does that to you, that they honor you by saying, I trust you to do something on our behalf or my behalf, then being loyal to that person and doing what you were trusted to do is a part of ethics. Of course, we've got law abiding. We talked about that being sort of the bare minimum standard. Focused on making these values and virtues a part of your culture. I think that word should say culture more than focused, but that it is something that people are really focused on, being truthful and honest. Now, I don't mean, you can tell a white lie when you're trying to get somebody to come to their surprise birthday party. But I mean, what we mean by truthful is providing truthful, honest, accurate information to our customers and to our candidates and to each other about the business services we're providing for them. Doing the right things right. So learning how to conduct your business in a professional, responsible way and doing it in a professional, responsible way. In 90% of the ethical problems we face, we know what we should do. The real question is whether we're willing to do it. And so, not knowing what to do isn't a lapse of ethics. It might be irresponsible for not taking the time to learn what you need to do. But when you know something is right or wrong, making the right choices to follow the right path is important. So we're going to talk a little bit about the ACSESS Code of Ethics. Before in our previous sessions, I explained to you that ACSESS member companies are the members, not the individuals, and the employees of the company are vicariously and automatically members or representatives of ACSESS. And each member company, when they make their application, has to prove a bunch of things. And one of the things that they also do is they make a commitment to uphold the ACSESS Code of Ethics. So as members of the Association of Canadian Employment Staffing Services, we commit to uphold this code of ethics and standards and to display it prominently in our place of business. So, a lot of people don't come into your workplace anymore, so maybe the website is also a place it should be. We support the principles set forth below, and we're going to talk about those principles in a moment, and acknowledge that compliance of these principles is in the best interest of ACSESS member companies, their candidates, employees, clients, organizations, and the reputation of the industry as a whole in Canada. So, this is one of those poll questions, as if we were in the same room. Who's responsible for ethical behavior? A recruiter. I need to keep moving. Sorry, guys, I've got to change my screen layout so that I can actually see what I'm looking at here. A recruiter, customer, candidate, employee, recruiters, customers, employees, and industry. Hey, listen, the bottom line is that everyone who is involved in the industry, whether you're a recruiter, whether you're a customer, whether you're a candidate or an employee, every participant in the process has got a responsibility for ethical behavior. That includes our customers who use us, that they ought not to be behaving inappropriately towards, say, for example, our employees or our candidates. It includes the candidates who are applying through us, that they ought not to perform inappropriately just so that they can get a job or make some money with one of our customers. We all share in our responsibility. So we talked about the principles that ACSESS has defined. Principle number 1, we will observe the highest principles of integrity, professionalism, and fair practice in dealing with clients, candidates, employees, and all regulatory authorities. And we will respect the confidentiality of records in accordance with the law and good business practices. So basically, this one is saying we're going to make sure that we know the law and understand the law. And in particular, we're going to respect confidentiality as we kind of move forward. So what are some examples of ethical behavior? So for example, we talked about this earlier in terms of the high level, but more specifically to our industry. Maintaining a promise of confidentiality. So it's one thing to say that you have a confidentiality policy, but doing it is important. Always seeking authorization for disclosure. So getting permission from candidates to submit their resumes is important, or getting permission from a customer to, say, for example, post their job on the internet is important. And again, I'm struggling with the way my screen is laid out, but I'll just leave it the way it is. Knowing complying with legislation and regulation. So you've gone a long way in choosing to register in the CPC courses, because we've spent literally 6 or 7 hours so far going through various legislation and regulations that affect our industry. Honoring contractual terms. So part of ethics is knowing what's in your contracts and doing what is expected of you because you said you would. Equality, fairness, equity, respect, all the things that we talked about with respect to discrimination and opportunity and culture in our organization. And then, of course, honesty and accuracy, truthfulness in our interactions with our customers and our candidates. So what are some examples of some bad things? So, so far it all seems rather generic and maybe quite obvious. But neglecting to perform a reference check or falsifying a reference when filling an order. So if you tell the customers you're going to do reference checks and you don't do them, or you get a faulty reference and you don't disclose that to the customer because you think, I like this candidate, let's just not tell them about that reference, that would be considered a breach of ethics. Misclassifying workers and not making legal deductions and avoiding employer obligations. So we talked about that in great length, about the nature of an employer-employee relationship and the difference between an employee and an independent contractor. So there are organizations out there that pretty much say, hey, you can come and work for us, but you better go find a lawyer and go register yourself as a independent contractor, self-employed, because even though we're going to treat you like an employee, act like an employee, pay you by the hour like an employee, and meet all of the conditions of being an employee, we want to avoid our obligations of being an employer and take away all your rights as being an employee. So why don't you go down the road there and register, get a GST number is often what some people who don't really know how to express that. Why don't you go get a GST number and come on back? That would be unethical, inappropriate, and in some provinces, it is specifically written to be a violation of the Employment Standards Act, the Provincial Act. Direct recruiting of a candidate previously placed. Poaching, stealing the same person that was placed. So we know, I don't know how often this really happens, but I do know that it's the most common thing, whether it's true or not so true, that employers who are not accustomed to dealing with agencies talk about. It's their biggest concern. How do I know that once I've paid my fee to you that you're just not going to recruit that candidate out of my organization and place them somewhere else and make money off them again? Well, because it's a violation of the Access Code of Ethics and Standards, and it's against our corporate culture, and we just will not do it. And you need to make people, help people to understand that this is an important part of the differentiators in your organization and in you that they can have confidence in as a supplier. Lying to customers regarding absence, lateness, etc. So misrepresenting your experience with a candidate or a temporary worker would be considered unethical. Contacting a candidate's current or former employer for a reference without permission or knowledge. Boy, aren't we all really sort of just, isn't it enticing or alluring to want to pick up the phone and phone the person you know who works for that company and ask them what they think of this particular candidate who you just interviewed? Or to do a blind reference or to send out. What if that person is still working there? What if it's a subsidiary company of the place they work for now? What if they really are just hire kicking and they have no intentions of leaving that job? What if the person you call has got a grudge and decides that they're going to tell everybody in the world that, or they're unprofessional, they're going to tell everybody in the world that you're looking for a job and screw the candidate over in terms of their reputation with their current employer. So having permission to do reference checks is important. So here's a little sample. Your customer, ABC company, spends about $800,000 annually on temporary staffing and contract staffing and contacts you with a 4-month order. They indirectly hint that you restrict acceptable candidates on a discriminatory basis. So they've asked you to, they've given some criteria to you in their selection criteria and their preferred candidates that breaches the areas of prohibited grounds under the Human Rights Act. So you take all the details and emphasize that you will work hard to provide the best candidate possible based upon the required skills while adhering to non-discriminatory practices. So you say, so that one basically says, yeah, I'll do it for you, but not that part. You can ensure that you get a detailed request in writing so that you can direct blame to them if we get caught. Well, that doesn't sound so good. That we're going to go ahead and do the bad things and then blame somebody else because they asked us to. Hand the assignment to a tenured recruiter who is less uncomfortable with cooperating in discrimination, specifically for this very important top client. Well, if you work for a company that's the way that you solve your problem, then obviously ethics, integrity, and legal conduct is not a part of your corporate culture. So I don't think that's the right answer. Go along with it. and if the discrimination does not relate specifically to a legal prohibited ground, physical attractiveness. So there are, in other words, they gave you a criteria that seems wrong, but it's not covered. Seems wrong, but not covered. So earlier on, we said, hey, just meeting the minimum standard with respect to the written law is the minimum standard, doesn't necessarily mean it's ethical. And so I think in that particular instance, we might want to go a little bit further and say, exactly what is it that we're trying to achieve? And maybe redefine the criteria in such a way that helps us achieve the objective without using inappropriate selection criteria. Sorry guys, I have a new phone and I thought I knew how to turn off. So different switch. My ringer. So, we want to make sure that, boy, I lost track of where to go along with her discrimination, not related. Oh, yeah. So setting the minimum standard, just because it's in the regulation, is the minimum standard. It's not necessarily ethical or right. And so what we often do is we go back and ask the customer what they want to achieve in their objectives. What is it? What skill, what goal, what's the outcome we're trying to achieve? Then we help them redefine their job description, which will probably, say, for example, if they limited physical attractiveness when they really needed something else, somebody who will fit into it's for a model will fit into the designs, or if it's, who knows what it is. But we might be able to even broaden the scope so that we can now look at more candidates than otherwise would have been set by their limited description, and yet still achieve their objectives. It's just that we didn't achieve their objectives using inappropriate criteria. Inform the client that they will be obliged to use their company-specific criteria after you have given them a short list of candidates to consider. So, this is basically saying, guys, if you've got something in writing, you need to follow what you have in writing. I don't think that's good enough. Who knows what they have in writing? So answer number A is our example here. We take all the details and emphasize that you will work on it, and you just won't adhere to the particular discriminatory grounds. And again, I like to coach people to say things like, geez, that age requirement that you've put in there is something that we can't do. As a matter of fact, we don't even collect that information. We don't know that information, and we're not permitted to ask that kind of information. I think you know that, but I'm sure that what we're trying to do is we're trying to accomplish something. Like, for example, is it the database that it's so new that, we're trying to get people to know that database? Or is it the hours of work that, because people have to be able to get to, work at a particular time? Like, what is it that we're trying to accomplish here? And then help them redefine the job description in a particular way. And you don't have to say to them, you're wrong, that's inappropriate, that's illegal, I'm going to ignore that. What we want to ask them is, what is it that we're trying to achieve? And let's determine whether or not what you're trying to achieve is with legal and not prohibited. Principle number 2, the ACSESS principle number 2. We will provide leadership in the adherence to both the spirit and letter of all applicable human rights, employment laws, and regulations. We will treat all candidates employees without prejudice, and we will not accept an order from any client that is discriminatory in any way. So bare minimum standard with principle number 2. We've talked, I'm not going to spend a lot of time on this because we already did a full session on it. And again, I want to point out to you that if you pull up the presentation documentation from our human rights section, probably find the language on the screen is similar, but not exactly the same. And that's because different provincial, federal legislation, different aspects of the law, whether it's human rights or some subset of of um, of other legislation, like the Employment Standards Act, for example, might use slightly different language, and the courts basically look at what's the intent of this. So when we talk about, I've bundled together here on the same line here, race and related grounds. So race and related grounds is not a legal term, but color, ancestry, place of origin, ethnic origin, citizenship. These are all examples of exact words that are used in different specific legislation. And so it's important to understand the principles that are set forth here, because sometimes there's some little subtleties of language. It's not a word game where you can slip between the cracks because it doesn't exactly match the word that you're using at the time. Here's an example. The client requests that we recruit millennials for, what is a millennial? I can't even remember the age groups now. Recruit millennials for a role of designer. The company is a startup, and they request young, dynamic, there's another word, people to work with them. A client indirectly hints, well, let's just deal with them. Let's deal with that one first. The client requests that we recruit millennials. So again, this is a situation where we say, hey, you know, we can't really associate the hiring to this for the job based upon age, but let's try to figure out what it is you're trying to accomplish. What are the skills that are necessary for this job? What are some of the personality traits that are appropriate to make someone more effective in the job than the personality traits of another person? What are the experience that a person needs? What are they going to do? And is the person a good match for doing that job, opposed to making some generalization that a millennial would probably be more qualified than a non-millennial, than a Zoomer. Point number two, a client indirectly hints that the recruiter only represents female candidates for the front reception. Again, same thing. Let's talk about what happens in this job. How many people do they greet? Do they need to have different languages? Is there a technology? Are there certain kinds of other functions that they're going to do there? What is it that you expect them to do while they're greeting people? And then possibly selling to the customer that the most qualified and best fit person for the job may not be female. And as a result of that, you're going to be presenting to them a variety of candidates that you think are the most qualified for the job. A client has a role for a forklift driver. They must have their license, so that's a bona fide occupation requirement. Be able to lift 15 pounds. In most provinces, there is a weight limit. You, for example, you can't, I think the number now is 40 pounds. You cannot require a person to lift more than 40 pounds, but you can set a requirement saying that this person is physically capable of lifting up to 40 pounds. Although I think 40 pounds is a lot. So you might not want to have people constantly lifting 40 pounds unless they're going to take time off for a bad back. So 15 pounds is well within the limit. That's moving boxes around and things. Must have their license, bona fide occupational requirement, be able to lift 15 pounds. They request to have Brian back. Well, that's legit. That's a bona fide occupational requirement. You can say Brian has done this job before, and Brian is experienced in this job, and Brian has knowledge of the workplace, and Brian meets all the criteria. Is Brian available? That's perfectly acceptable. And if he's not available, then we need to recruit another male person for this role. So the only part about that whole description is the male part, you know, and if he's not available, then we need to find another candidate who is qualified like Brian. Not same gender as Brian necessarily, but qualified like Brian and like the qualifications that were provided in the description. Honesty is the only best policy. Principle number 3, we will take all reasonable steps to provide clients with the accurate information on each candidate's employment qualifications and experience, and we will only represent those candidates who given us authorization to represent their application for employment. So fixing up resumes that might not accurately represent a person's background and skills at You can always add things that they have and they've done and they've got skills in that were not on the resume. You can always ask, say, hey, can we fix up your resume and include those things, that piece of equipment, that software language, that, driver's license, that's something, can we get that on your resume? You can always include things that are factual, but inaccurately representing a person and knowingly do so would be a violation. And of course, we already talked about having authorization. We talked earlier on about having authorization to do a reference check, but it's equally important to ask for authorization to present that person's resume to the customer. So this
And
is a
Steve,
conundrum. Yes, ma'am.
should we get it in writing? Is that best practice?
Oh my goodness,
Or-
absolutely.
Okay.
Absolutely. A lot of particularly temporary help staffing companies try their best on the application form to have it say something like, a big, real generic statement like, I understand that, ABC company will be representing me in a variety number of employers, and I authorize, ABC company to disclose my private personal information, including my resume, for the purposes of finding a job or being placed in a temporary contract, and that the use of my information will be restricted specifically to that purpose. So that's fine, but that really only covers you off really with respect to the collection and retention of information under PIPEDA laws. That doesn't really deal with the issue of honesty and integrity when it comes to the very specific presentation of a resume for a very specific job. So it's perfectly fine for you to send a message to somebody saying, and this is the conundrum. A company, say, for example, your customer wants confidentiality, but of course, they can't remain confidential and interview somebody. They can't remain confidential and see a candidate. So, you might be able to say, hey, I've got a job at ABC at XYZ Bank, and I'd like to present your resume there. Can I have authorization to do that? And they say, sure. Now you've protected them enough in the sense that you didn't disclose yet the contact person, the telephone number, the email address, the location. And so the chances are that that person's going to go running around and going through the back door and trying to get a hold of them directly and do all the bad things that companies don't want you to do, or disclose to other employees that that job's available in case it's a confidential search they don't want you to do. And but the more specific you could be, the better. Some companies try to say, tell us those places that you don't want us to present you to. I don't know how well that would stand up in the court of law if there was some harm caused to the individual. And I don't think that's a best practice. I don't think that would be considered a best practice with respect to honesty and openness. But it is okay at the beginning in a broader sense so that you kind of know where you're going, to say, to get people to sign off saying, I understand that you're going to do this with my resume and I give it to you for that purpose. And then other people, and to ask the question, you don't want us to specifically, or talk to customers about you and they tell you that, don't go to my current employer, don't go to my dad, or whatever it might be. But once you get right down to the specific thing, it's probably good. And you don't need to get in writing like a letter. An email's fine, saying, just want to let you know I'm going to be sending this over there. Can I get an authorizer from you to do so? And they say, yeah. And it can also be done sort of in an indirect fashion. Like you've got this email going back and forth saying, I got the job at this company. What are you interested? Yeah. Okay, I'll submit your resume now. I'll let you know how it goes. And you've got this ongoing conversation. That's fine. That's fine. What we're really talking about is the companies that just get 100 resumes and 100 job orders, and they just start uploading all the resumes into the portal or the VMS system or something like that. and they just start uploading them, trying to get the person's name in front of onto the job list first without ever really knowing, or the person ever knowing, that they're being represented there. And that's where all the problem starts, when companies start racing to be first without having authorization. Case study. Oh, this is an interesting case study. The story behind this is that many years ago, I was asked, I didn't put this case study in here, by the way, it's just a coincidence. Many years ago, I was asked by a staffing company, the Versus staffing company up in the top right-hand corner, to do an expert report for them with respect to their conduct and behavior in this placement situation. And the story, I'm not going to read it. The story goes like this. Placement agency gets an, I'll give you more information. The placement agency got an order from a new customer. The new customer had hired a consultant, an independent consultant, to help them hire employees and do other consultancy type of stuff. And the consultant, on behalf of Leather Treaty, gave an order to the agency. The consultant said, you get me the candidates and I will do the reference checks. The agency gave them a price, a rate, and might have given them a guarantee, but it was short. Don't remember that part of it. That part's not necessarily not important. It was for a permanent job, and so they were going to charge a placement fee. It wasn't a temporary job that was converting, and they were not employees of the agency. They were candidates of the agency in this recruit and placement situation. The job was a general office administrator, with a significant component of the job in accounts receivables, accounts payables, making deposits at the bank, purchasing office supplies, and general office management. Wasn't a huge company, and so the person who worked in the office was responsible for a lot of stuff. The employee, while she was there for 2 years, participated in a ruse or scam to siphon off money from the company. I don't know the details of exactly how she siphoned off money from the company. She probably pretended like she was buying paper from herself or something and wrote checks to herself, but she slowly defrauded the company. So it was found that prior to joining Treaty Group, the employee had twice been criminally convicted of fraud against previous employers. So this was not a first rodeo for this stealer. After joining Leather Treaty Group accounting department, the employee walked away with an additional $263,000. So this is like, $10, $12, $15,000 a month, over a 2-year period. When Treaty Group discovered the fraud, it reported the matter to the police, and the employee was convicted criminally. So they dealt with it from a criminal conviction standpoint. Treaty Group thereafter obtained a civil judgment against the employee. So they got a court order saying the employee had to provide restitution, give the money back. And of course, the employee probably didn't have the money. So in a separate action, Treaty Group sued the agency as severally liable. So we talked the other day about several liability, which means that you can have a contract that severs the parties, so that you have got several parties that could potentially be liable, not jointly as one, because you can say joint and severally. So you can either be combined together. That would be, let's say, for example, an employee in their company would be maybe jointly responsible, or you could say the employee acted out of the best interest of their company and broke all the laws, and so maybe you sue the employee, but the company's not found liable. So jointly together or severally. So they sued them severally, sued her severally. Treaty Group thereafter obtained the judgment. At trial, Treaty Group was successful against the agency, although its damages award was reduced later on by 50%, given that the Treaty Group owns some negligence in failing to put in place the appropriate internal factors. So they basically said, hey, you left the door wide open and you ought to have known that this was going on. And you left one person responsible for balancing the books at the end of the month and showing you that they balanced, but nobody was auditing, checking, validating. You pretty much set yourself up for this. You ought to have known. And also, it turned out that the consultant that they hired, who said, don't worry, I'll do the reference checks, never did the reference checks. And he never stuck around afterwards in order to monitor, supervise, manage, and look over the shoulder of the employee. Now, the company, the agency was found liable in the first place because not because their contract was pretty vague and didn't cover a lot. So the contract didn't specifically say we're liable for any theft that employee that we place may cause. But they did have things like websites and brochures and all kinds of stuff that supported what their normal business practices were. And on those websites and brochures and their general marketing collateral, it said things like we have the best hiring practices in the industry, and we do thorough references and background checks to validate a person's, suitability to your job. And we have insurance. And, what does that mean? We have insurance. Well, it kind of implies we have insurance for something that is a benefit to you. Oh, but it didn't say what kind of insurance and what it covered. So in the absence of a specific contract, so we go back to what we talked about the other day, in contract law, there became common law, normal business practices that were standard within the industry and particularly reinforced by the general information provided in the public domain by the standards, the operating and business standards that the company operated by. And so they sued the company for $263,000 and they were awarded the $263,000, and they appealed it, and they were able to determine that half of it would go back to that, would not be there. But then insurance kicked in, and both companies had insurance against that sort of thing. And so it really was like 2 years of people pooping on each other and trying to cast blame on everybody else in order for people to try to be made whole throughout this whole thing. And it's really, really an interesting case. So some of the issues: there was no signed service agreement. It was a very, very loosely written document that didn't have signatures on it. There was an intermediary consultant who had some responsibility for vetting. Told you about him. The difference between reference checks and background checks. That was a big part of the report that I wrote, because there is a difference between a reference check and a background check. If somebody says, here's my last employer, and you call that last employer, and that's the only employer you knew about, and they said, yeah, great employee, perfect, then that's a reference check. But if you're doing a background check, you're validating the accuracy of what's on the resume, as well as potentially including things like criminal background checks or credit checks or other things. So the language that was used in terms of the background checking was in dispute. And so some of the documents in the public domain said reference checks. Some of the documents in the public domain said background checks. And so the question was, what was this company really required to do? And if it was only reference checks and the consultant said that they would do the reference checks, then why would they do it? By the way, also on the side, there was also a piece of paper, handwritten. This is now starting to sound like Donald Trump and something they found in a box or something. There was also a found piece of paper that had notes on it in the person's file about phone calls made to a previous employer to do reference checks and some little point form notes. that seemed to indicate in the little point form notes and very few words that they got in contact with somebody from a previous employer, which happened to be one of the previous employers that had been stolen from by that individual. So then the question arises is, well, what did you know? I mean, we now know that this person worked for that company and they stole from that company and they were convicted of a criminal offense working for that company. And you called that company and were told something. Were you told not that there was a bad reference? Were you told that they were a thief? Were you told they went to jail? What were you told? And the agency couldn't say. They, this is just a piece of paper, boy. That was 3 years ago. Don't really know even whose handwriting that is. And so, again, good business practices includes good documentation of the things that you do, let alone stating what you're going to do, making a promise, having it written into a contract, clearly defined and a signed contract, and then fulfilling your obligations, stating what you're responsible for and what you're not responsible for. And of course, if you have insurance, what the insurance is for and who holds what liability for certain things. We'll go over all of those things again later on in the presentation. There was a possibility of dishonesty regarding the reference findings. So that's a little piece of paper. There was some issues around industry norms. What did other companies of a similar size and a similar do, and what was expected in industry, and what did these words mean that were being used on the website? So the website promises, the client's lack of checks and balances, that was an issue. What did they do to mitigate their damages? And then there was a big fight over the calculation of the damages. How do you calculate that stuff? Hard to keep track of. And let's see if we can get my screen moving. There we go. Frozen. There we go. Okay, so some examples of what not to do. Well, first off, don't walk across that little gap there in the stairs. That's probably a bad thing to do. So don't make up references or ignore unfavorable ones. Don't alter or fail to disclose unfavorable test scores prior to presenting a profile to a client. Not seeking out approval from a candidate. We talked about that. Falsifying background screening. Background screening, different from reference checks. Skill levels, candidate preferences. These are all things that we don't want to misrepresent a candidate over. It can be risky, it can be costly, it can be litigious. Principle number 4, we will supply candidates, employees with complete and accurate information as provided by the client regarding the terms of employment, the job descriptions, and workplace conditions. So this is the exact thing, but going the other way. Are we providing all the right information to the candidate about the job? Keep in mind also that we talked about this, written right into the employment standards legislation back in 2012, the Ontario government made it law, a list of things, I think it's in here, a list of things that you must provide to a candidate before you send them on a temporary assignment. Well, quite honestly, pretty much the exact same information is important to provide to a candidate before you send them for a job interview or before you start to have them sign off on a job offer if it's permanent placement. So here's the case study. We placed an employee with client as data, and this is an interesting one because I'm not sure it's an ethical breach. It's worth discussion. We placed an employee with a client as a data entry operator, alphanumeric. Who's been around long enough to know that we used to place alphanumeric key to disk operators that typed at 18,000 keystrokes per, per hour. When we contact the employee a few weeks later, we find out that they're not only doing data entry, they're also using Microsoft Project to track milestones for their manager and working in Excel and creating pivot tables and running analysis and weekly charts and reports and doing really important skilled stuff, but they're not just doing data entry. The question below says, how should a recruiter handle this? Well, the first question is, Is this an ethical violation by the customer? I see some heads nodding up and down. I don't know. I don't know if it's an ethical violation. Did they knowingly give the agency the description for a junior job so they could pay a junior rate and then look at resumes looking for people who are way overqualified and then bring them in and have them do the way overqualified work and exploit that worker by saying, yeah, but you're only a data entry operator. We're only going to pay you minimum wage, even though that job pays $25 an hour. Was it like some sort of intentional breach, or did this data entry operator apply for a data entry job and go to a data entry job thinking it was data entry, and while they were there, the customer and the employee both went, wow, I can help you do that. And they go, really, you know how to do that? Oh, geez, yeah, you don't have to. Oh, let me put that into a spreadsheet for you. Oh, geez, I can run a report for you. And then all of a sudden they become more valuable. So from your standpoint, if you place them into um, a permanent job, it's none of your business. Really. I mean, it's none of your business. You did exactly what you're supposed to. If you place them into a temporary job, you got to ask yourself, how does my employee feel? Is this fair? Is it appropriate? Can I act in everyone's best interest and intervene and possibly help negotiate a wage increase for my employee so that they're treated and paid commensurate with the skills and the performance of their job? But is it, on the face of it, an ethical violation? The answer is I don't think so. The question is, what obligation do we have to make things better or right or righter? I don't know if that's a real word. And, I think there's some subtleties in this about how people feel about what it means to be fair, what the definition of fairness is. You know, I suppose nothing would be worse if you'd place the person into a temp to perm, and in 13 weeks from now, they're going to potentially transition to a full-time job with that customer. And when they potentially transition to that full-time job with that customer, I'm just making this up as I go, they're going to get the job as the MS project and data and, assistant who does all these financial reports and get paid appropriately. And yet you screw over their reputation or their relationship with them because you intervened after 2 weeks to try to get them a raise. And they were like, what, you just put them in here and then you start asking for money like 2 weeks later? Like, every situation has its subtleties and its gray zones. So this one on the face of it is an interesting one because I'd sure like to know more information before I stuck my foot in it a little bit too further. Oh, yeah. So I said to you that with respect to Ontario, and this is a great practice everywhere, but Ontario is the one that's codified it. Everyone should be providing accurate information to their candidates about all of the jobs they send them on, but Ontario has chosen to put it right into the Employment Standards Act. So a temporary help agency is required to provide the following information to the candidate before they start, or at least at the most reasonable opportunity: the legal name of the client, as well as any operating or business names of the client. So in my old company, one of my old companies that I sold to my partners and my share of it in 2012, we had a corporate name and we had 7 operating names. So each vertical or specialty area, the IT group had their own name, and the office had their own name, and the, contract IT folks had their own name. And so those were operating names that we were legally allowed to use because they were registered names, but they weren't companies. They were operating as. And so theoretically, always, if we said, hey, you're being hired by ABC Staffing Company operating as temporary help group, being placed with ABC Bank, operating in the whatever name subsidiary. So letting people know who the heck they work for is now written into the law. And very often we let's say, oh, you're going to work for, this bank, or you're going to work for this company, and we don't take the extra step to make sure that they understand what their legal entity is. We need to provide them with contact information for the client, including the address, phone number, and the contact name. So they need to know, who do I contact at the customer's office in the event that I get hurt or something goes wrong, or I can't make it to work, or something bad happens. Who's my contact at the customer? Instead of them just walking in the door, not knowing, hi, I'm Steve, I'm from the agency, and that's all they know. The wage rate. So we need to tell them how much they're going to get paid before they go. The hours of work. They need to agree to the hours of work, because the last thing we want to do is send people out to a job and then find out that it's way different hours. And then, of course, they are told that they have to work those way different hours and then get fired because they refuse to work those hours or whatever. And, the interesting thing was they might have accepted the job from 9 to 5, but they couldn't work until 6 because they got to pick their kids up from the after school program that costs $60 an hour to keep them in, and they get kicked out of the after school program if they come late twice. So having an employer who doesn't respect family status covered under the Employment Standard Act, when they had an offer that was in writing saying 9 to 5, then this gives protection to workers so that they have got a piece of paper that tells them what they were offered, and it protects them against inappropriate behavior of customers or agencies. The hours of work, general description of the work. It doesn't have to be super detailed, but a general description of the work. The estimated term. So, it's a really, 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 really good business practice in the staffing and contract business to give people an end date. If you don't know an end date, then say this contract will expire on such and such a date, maybe a year from now, or 3 months from now, or whatever might be appropriate, with the opportunity to be renewed on mutual consent at the same terms and conditions, which means that this could go longer than a year. This is a year. I'm going to give you an end date. And the reason for that is all because of the things like termination provisions, because when you start to give people notice, remember we talked about the difference between notice of the end of an assignment and the notice of the end of employment. So we start to get all this stuff out on the table. Once you renew a person's contract twice and you get into the third term, courts tend to not pay much attention to any more renewals. They tend to start to treat it like a permanent job, and renew, don't renew, doesn't matter to us. This was obviously an ongoing job that you just have intentions of continuing to renew all the time. And somebody was trying to cover their butt by having these fake renewal dates that would allow you to get out without providing notice or reason. So end dates are really important and really helpful. Multiple renewals over a long period of time start to become less and less meaningful. They're still.
Steve,
Yes,
if it's
ma'am.
multiple dates within different customers, would they still say, hey, you've had Sally working for you at multiple customers for 5 years? They are clearly a more
Yeah,
permanent.
so that's a really good nuance, and that's a good question. And the answer is, this is really going to work in your favor to have multiple renewals, and it will be treated like continuous employment. They'll say this person worked for you for 5 years, and so they're entitled to whatever 5 years worth of tenure is in terms of notice or pay in lieu of notice. There's no, that wouldn't change whether it was one contract or multiple contracts. So but the multiple contracts, multiple customers, will help you to establish that you didn't necessarily need to have cause for the termination, because it was very apparent that each one of these was individual with an end date. And that there was no guarantee that the next one was going to start or be available. And so, getting lucky that you had 3 or 4 or 5 concurrent ones that added up to 5 years, by having multiple signed end dates and contracts, you've established that that is the business that you're in, and they knew that was the business that you were in, which is different than putting them into one customer, and 17 years later, they're still just renewing every year. Now it's like, hey, man, it's been 17 years. Like, these renewals mean nothing. They just basically are, resetting my pay rate for the year, but it's not a termination or an end of contract. So, very helpful with one customer, but it diminishes over time. Very helpful with multiple customers, and the value that it serves does not necessarily diminish over time. If that answers your question. The information can be provided verbally when the work assignment is offered and must be provided in writing as soon as possible. So you can phone up a candidate and ask them if they want to go, and they say, sure. Then they go to work the next day, and then you do your paperwork the next day. Nothing seriously wrong with that. Because of the nature of the industry, the legislation knows that we often fly by the seat of our pants, and if it were not for the last minute, most things wouldn't get done. Principle number 5, we will not recruit, encourage, or entice a candidate whom we have previously placed to leave the employ of our client, nor will we encourage or coerce an individual to leave any temporary assignment before the stated completion date. So this kind of covers off 2 things. It's like, wow, we're not going to place a person into a perm job with a customer, and we're not going to entice them to leave. So we're not going to try to recruit them out again to go work for another customer once they're placed there with our hands off from us. And if we put somebody into a customer, say for 3 or 5 or 6 months or a year, we're not going to get halfway through the assignment and decide that we should pull them out and place them someplace else. So we're now back in the room. Show of hands. Under what circumstance would you entice a candidate or employee who has been previously placed at your client's site to take another role you were working on? So we just said we won't. Let's find out whether that's true in all cases. When you place the candidate to clients and the position has turned out to be less than the client promised. Well, just because the client didn't stand up to their position, you could ethically, morally, and from a business standpoint, decide that you want to intervene to try to help resolve the situation so that everybody's happy. You could do that, but taking the person out of their job, not do that. When the candidate employee approaches you saying he or she will be leaving anyways, and they trust you to help choose the next direction. Look, if this job's terrible, I'm going to be out of here. I'm leaving at the end of the month one way or another. I'd really like your help. And the answer to that is, I would really like to help you if you think there's something we can do to intervene to help you stay in that job. But if you do choose to leave, then you're more than welcome to come here and make application or to make yourself available through us in the future. But under contract, I'm obligated to not consult you to give you advice on leaving. I can give you advice on staying. Can't give you advice on leaving. And I'm sure that they'll understand that. And they'll say, what do you mean? Say, well, the customer paid a fee. I can't, it's bad enough that I know, and I'm not going to tell them. Now, but I can't be consulting you and assisting you when I've charged them a fee to place you there. Would you like me to help you to try to resolve things again? Maybe we can intervene and get you the right job, or get people to understand that you're being, harassed or whatever it might be. When the person is number C, when the person is obviously unhappy in their current position, same as B. D, when the client is planning a layoff sometime in the future. So this one is and E is under no circumstances. And so generally the answer is under no circumstances. Number D has got some caveats to it. So it has happened, not many times, in my 40 years of being around the business, where a customer has contacted us and said, hey, confidentially, in the next week or two, we're going to possibly be doing layoffs. You know, rumors are flying around here. Everybody kind of sort of knows, but there's been no official statement. We're scheduled to make a statement on, a week from Monday, and we're trying to get in place some of the services and help we can get from agencies. And we're also trying to get an understanding of the marketplace. So if we were to lay off like a bunch of mechanics or journeyman millwrights or administrative support staff or human resources staff or salespeople, what are the chances of them getting a job? What are the chances that you can assist them in getting a job? And so typically nowadays that question would more likely go out to an outplacement company that specializes in that service. But I don't put it past companies to consult with their suppliers of staffing to also assist them with that. So there could be unusual circumstances where the customer gives you permission to do something or even encourages you to do something, which would be probably appropriate so long as you're not misrepresenting anybody at any point in time or doing something that you didn't have authorization to do. But in the absence of some really weird circumstance under D, E is the answer that we're all looking for. And I don't know why. There we go. There's a nice slide. Discussion, what to do. Recruiter needs to fill another role. We're going to take a break in 15 minutes as usual. We'll take that break for 10, just to give you a heads up. Recruiter needs to fill another role ASAP and the margin is higher. The recruiter wants to pull an employee from a national account where the profit margin is very low. What do we do? So in that particular case, the answer is find another employee. You don't place people just because you want to negotiate a contract with a large supplier and you negotiated a particular margin or markup on your temporary payroll cost. And that's the nature of the business. You went into it with your eyes wide open. You made the deal. So recruiting that candidate out of there to place them somewhere else for more profit per hour would be an ethical violation. Number two, the employee tells you that they have another opportunity and they want to leave this assignment. We kind of talked about that. They're leaving the assignment. How can I talk you into staying? What can we do to make you happy? What's the reason that you're leaving? Is there something we should know? Can you give us notice? Can you give us 2 weeks notice? Can you give us 1 week notice? And then asking the person to say, hey, look, given the fact that you're going to be leaving there a week from Monday, we have to disclose this to our client. And so then you get into this thing like, is it better for me to wait until tomorrow afternoon when I've got the replacement person all lined up? And when I phone the client, I tell them, hey, Mary's leaving, John's going to take her place. Is it better for me to tell them now? And I don't have an opinion on that. Just that if you go for an irresponsibly long period of time without disclosing to the client, that's unethical and inappropriate. And if it's to your advantage to tell them at a more appropriate and convenient time in the reasonable, foreseeable future, I think that's probably okay. But those are pretty sort of generic kind of ways of describing it. If you drag it out for a week and a half so that you've got finally have a solution and you're taking the risk that you won't have a solution, then not disclosing that to the client and putting them at risk that they may have an empty desk would probably, in my opinion, can be considered to be a ethical, inappropriate manner in solving that problem. Number three, the recruiter locates a candidate who is currently working for a competitor on a 3-month assignment. They would be perfect for the job that you have, and your job pays more money. Can I recruit them out of there? The answer is yeah, you can. You can recruit people out of jobs. It's not unethical or inappropriate to offer people jobs. The person started yesterday and you recruit them out today. is being nice, ethical? I mean, to say, hey, you haven't even got a chance to, everybody's going to get screwed over if we pull you out of there, if we recruit you out of there. Asking an employee, a potential employee, to give an appropriate amount of notice given their tenure before they come to work for you would be appropriate. Is it a temporary staffing company that you're going to cause significant harm to their relationship because this job just can't be refilled? It's going to hurt the customer. It's going to hurt the staffing company. It's going to hurt the industry's reputation. It's going to hurt your reputation when they find out that you were the one that scooped them out of there. I mean, hey, way back in the day, there was a particular word processing equipment that was used in 2 banks in Toronto, and there were about 100 operators of that word processing equipment that were available through 2 or 3 agencies. And, going across the room and recruiting the other word processor operator from the competition to come work for you, to go work for the other bank, was totally inappropriate. That was using the information, the opportunity, and the trust that you were given to put your employees into a workplace, and then using the information that you gained while in that place to cause other people harm for your own unfair advantage. That's what they refer to in law as tortious interference. And contractually, in most contracts, it would be limited, and ethically, that kind of behavior is wrong. So, there's a slight difference between, I had a candidate apply for a job 3 weeks ago. We finally got something that suits them. We called them. They said, oh, geez, I started a job last Monday. And then you saying, should I recruit them out of that job to start my job or not? I think you need to take it. The answer is generally no. Generally no. But I don't know if it's 3 months, 4 months, 6 months after they started there. Do they like their job? You're going to hurt anybody's reputation. It's not unfair competition. You didn't get the information unfairly. So you got to put everything on balance. So the important thing to know about that example is don't just do it. Don't just do it. Take a look at all the circumstances and what the impact of it is. Principle number 6, we will not restrict the right of a candidate or employee to accept employment of their choice. This one's pretty straightforward. This just means you've got a candidate who's being offered a job with your customer. The agreement is between you and your customer, not between you and your candidate. It is illegal to charge the candidate a fee in Ontario, and it is in Ontario and in most provinces. And in Ontario, it's written right into the legislation that you will not interfere with their opportunity to gain that job. So you can say to the customer, hey, we had a signed agreement and you owe us a fee. You don't need to involve the candidate. The customer said, send me resumes. You sent resumes. They interviewed people. They chose not to hire. And then 2 weeks later, you find out they're hiring them. You can send a fee to that customer, whether they pay you or they don't pay you, whether you have to fight over it or collect it or whatever. But you don't go to the candidate and say, don't take that job because they refuse to pay. That is illegal in Ontario. And even if it's not illegal, it's inappropriate. We don't tell the person they can't accept the job when the contract for payment is not between the candidate and you. Principle number 7, we will not misuse membership privileges for the purposes of recruiting staff. So what they mean by that is that you're going to go, you're going to go to a chapter meeting, for example, on this Thursday afternoon, and you got some openings in your office. So you go to the chapter meeting and tell everybody, hey, we got a great job, pays this amount of money. How'd you like to come work for us? Well, we are not allowed to use our membership privileges by phoning the list, using committees, going to meetings to recruit our other members' employees. It's kind of like the old saloon days where all the cow folk would say, hey, we might be enemies out in the field, but we all need to drink in the same saloon. So hang your guns at the door. Otherwise, we undermine the importance of the saloon. And so if ACSESS is the saloon and our job is recruiting, let's hang our recruiting guns at the door, because we need ACSESS to help us to fulfill our legislative negotiations and representation and our training and our public policy initiatives and so on and so forth. And so we shall not use the skill that we have in our business to cause harm to the others in our business, and use the industry association as a vehicle in order to do that. Some way, for some reason. Principle number 8, we get 6 more minutes before break time. We will derive income only from clients and make no or direct or indirect charges to candidates' employees. So we talked about that the other day. We don't charge candidate fees, and the best thing to do is to avoid anything that might look like you're charging them fees. So we don't charge them to fix their resume. We don't charge them to buy the uniform. We don't charge them to, do any of that stuff. Just don't charge candidates. And as a matter of fact, it's against the law in Ontario to deduct anything from somebody's pay, except for those things that are statutory or court ordered, like a garnishment of wages. And so stay out of that game. Your relationship for your payment is between us and our customers, not between us and our candidates. Nobody pays to get a job in Canada. Principle number 9, we'll maintain the highest standards of integrity in all forms of advertising, communications, and solicitation. So we're going to tell the truth when we advertise, and we're going to be accurate. And so when we're dealing with job boards, say, for example, we want to keep our posts up to date. We want to make sure that they're accurate. We only want to post jobs that are currently open, unless specified. We can say ABC company is a specialist in providing call center representatives to a variety of banks, insurance companies, customer service organizations, and call centers. And we are constantly recruiting and hiring. We want people like you to become part of our team. That's okay. You can do that. And then you can say, hey, you got to wait a week, when it comes available before you start, or before we can send you some places. That's fine. But say, if it's don't do generic advertising and make it sound like it's a specific job. If we're going to put any pay rates in our jobs at all, let's make sure that they're accurate and not overstated or understated. Be careful with unintended or implied violations of human rights. People do that all the time. Energetic recent graduate, and sort of implies young. So it's an age prohibit area of prohibited grounds. Protect your client's identity. Clients don't want you advertising on the internet or in newspapers or anywhere else with their name unless you specifically give them authorization to do it, and it's part of their strategy. But they don't want to have you using their name to promote our business. Protect candidates' privacy. Acknowledge applications when they come in. Thank you very much for your application. This is going to be the process. Pay attention to wrapping and auto post. This is an important one. So if you've got an applicant tracking system that has a job order management system, and you create, so for example, in one of my companies, we have got a whole bunch of template jobs. We're in the home care business, so they're like 6 different kinds of nurses and 6 different kinds of caregivers. There's like 12 really standard job descriptions, and they vary when they start, when they finish, whether the day, night, weekend, part-time, full-time. And so we have a template. So we go and we say, okay, we're going to create a job. We take this job from a template. We customize it for whatever the little customizations that we need to go there. We go post, and it goes up to our website. But then it also goes out to Indeed and to Facebook and to, I don't know where, to different, to ZipRecruiter, I think. And, it goes to different job boards. And if we have and we choose to use Career Builder or Monster and pay for post on that, we click a little radio box and it goes there. And when we built this migration, we call it aggregate technology, so it aggregated to everywhere. When we built this technology or implemented it, we wanted to take a look at what happens when we put HTML into a header and we put bold or underlined or email addresses with hyperlinks. What happens when it goes through that internet thing that causes it to post in another thing? Did it work right? Did the spacing work out? Did the carriage returns and line returns and paragraph returns work out? Did the email addresses turn into email addresses, or did it say, show the HTML tags? How does that work? So pay attention to wrapping and auto post. We assume that they work, but they don't always work. And just because they work now doesn't mean that Facebook isn't going to change something in the way that they operate and work. That means it's not going to look good later on. Always have somebody proofread your jobs. This was an actual posting that was part of an actual posting. And these were all of the errors that were found in this actual posting. So proofread things, use templates, use standards, use spell check. And okay, so before we get into social media, it is now 2:30. We're going to take a break until 2:40, a 10-minute break. Please stay connected to our Zoom meeting. If you disconnect and disappear and try to get back in the room, that sometimes causes problems. Keep your microphone off. I'm going to freeze my screen and turn my microphone off, and we'll see you all back here in 10 minutes. Thanks. Okay, we are back again. So before we get started, hopefully everyone's there and you can hear me. Maybe somebody might want to just unmute for a second and verify for me that we're good and that you can hear me.
I'm good.
Okay, perfect. Any questions before we get going on the portions that we've covered so far? Right, that means I probably put you to sleep. Let's talk a little bit about social media. So, the question is, when should we use social media at work? And do you think that how you use social media at work should be extended outside of your regular working hours? Now, ACSESS has, in the past, ACSESS has run entire, 2-hour sessions at conferences on social media. And the lawyers have been there and talked about all the current cases that are taking place where employers have sued their employees or fired their employees or, implemented policies about social media at work. And so we've got some general principles. The first is to be mindful that if you're using social media at work or requesting your employees to use social media at work, to be mindful that your postings on social media will be available to the general public. And so anything that you put personally, if you're also doing work or people know where you work, they can somehow relate that to the company. Remember, once you post something, it lives there forever. And I'm sure you know this, but there are services available, some of them free, where you can literally go back in time and say, oh, what did that website look like on a particular day or at a particular time? And that information is like a time capsule and it's there forever. Now, certain social media sites like Facebook, once you delete something, it's not recoverable. But at least it's not now. It used to be re recovered by those services that basically captured all that stuff and stored it. Be respectful on social media, be truthful, honor privacy rights. So not using social media to somehow radar into X-ray into people's backgrounds. Express your own opinions. And when you do so, you might want to have some disclaimers that say things like the views expressed on this website or weblog or social media site are mine and mine alone, and don't reflect the views of my employer or other parties. Don't disclose confidential information or proprietary information. And, I'm not sure if the screen comes up next, but there's an interesting case that occurred in Etobicoke in Toronto about just prior to pandemic in 2019. And it was a car dealership where a person who worked for the car dealership, I think it might have been a salesperson, was asked to work on a Saturday because they're having a big open house and barbecue and free hot dogs and hamburgers for anybody who comes to, see their cars on the lot. And they decorated it all up and got the barbecues out. And they made all of their employees work that day. And one of the employees who had a family found that this was did not plan on working on Saturday and it intruded upon their personal time. And they were told, if you don't come to work, a big problem. And so the employee came to work that day and all day long posted disgruntled posts about their experience at work that day, about potential people that came to visit the dealership that day. And eventually, at the end of the day, the employee I think when it was all over with, threw the barbecue in the little creek beside the parking lot and took pictures of it. And the employee got fired. And, clearly this person was using social media to post disparaging comments about their employer while at work. But, this can also extend to things like, I can think of a personal example was years ago, we had a person work for us as a recruiter salesperson who had a social media site that didn't have a lot of privacy restrictions on, and the photographs and postings were all available to the general public. And the person, I'm not going to say it was there wasn't nudity or anything, but there was some pretty provocative postings. And, you know, for whatever reason, we're doing something at work and all of a sudden that person's profile is up on my screen. I think we were integrating job postings with their permission, integrating job postings to people's Facebook pages. And, so here I am looking, saying, I'm going to be posting job postings to this person's profile with these other pictures here that I don't think are appropriate, that don't represent the standards of which professional standards of which we keep in our workplace, clearly not work-related postings. And so, we ended up having a female manager, ended up having a female discussion with a female employee, and everybody agreed that we shouldn't be posting our work things to that person's social media account. And sometime later, like within a month, that individual resigned their job. And they resigned their job and they found a job somewhere else. And I can only attribute it to the fact that this made this person feel very uncomfortable, that things that they didn't want people to see in their workplace were now available to senior management who have seen it. And they quietly moved away. This was harmful, quite frankly, more harmful to the individual by having it had to be addressed or was addressed. And we didn't force the person to take anything down. All we said was, we don't want you posting your job title and your company on your website, and we're not going to be posting jobs to your account. And it didn't work out. It didn't work out for us. It didn't work out for that person. So these are sensitive conversations and discussions, and the best way to deal with it is to have documentation with a written set of social media standards that everybody understands in advance, so that you can isolate personal from professional. And I'll tell you, like, we at the time took great pride in our ability to post one job to our website and have technology that propagated it to every employee who wanted to participate, have those jobs posted automatically, going through their account to their LinkedIn accounts, automatically to their Facebook accounts, automatically to our corporate Instagram and Facebook and Twitter accounts, and to Indeed, and at the time Workopolis existed in Monster and so on. And so, we would post one job once and it would go everywhere. And our strategy was called 1,000 pathways. And so anytime we did that, then it created 1,000 pathways for things to come back to our website to see what jobs we had available for recruitment. And it was tremendously successful, except for it goes both ways, right? As soon as we started posting things to people's personal Twitter accounts and to people's personal Facebook accounts and to their personal LinkedIn accounts, they resided there, allowing people to now associate whatever that person's personal activities were with the corporate activities, and the lines were not clear, and which was approved company behavior and which was not. So having policies written in advance and having open discussions about what people feel comfortable with, they think is right, and also letting them know about what you get to look at and not look at and have access to is important. Particularly if they're using computers that are owned by the company, whether they're on-site or off-site. What technology do you have to take a look at their computers? Do you know what websites they go to? These are all things that companies should have very clear, defined policies about. And there's going to be some disagreement between those people who want to have absolute privacy and those people who want to have extreme integration, where the line should be drawn in the sand. And the important thing is not necessarily, the important thing is to try to get the line drawn in the right place. But the most important thing is that there's absolute and full disclosure with respect to what they are allowed to post, what you're allowed to post, what they're allowed to see, where things are allowed to be posted, when certain things are allowed to be used. Like, for example, I personally believe that recruitment companies should be giving people full access to Twitter, Facebook, Instagram, LinkedIn, while at work, because these are integral tools that we all use at work to get resumes and applications and to communicate with people. And, it's important that we have the ability to communicate people on the platform of their choice. I own a home care company, and some caregivers have really terrible cellular plans, but they live on text. So, for example, group texting with some non-iPhone accounts on some types of group plans won't allow you to group text. So as soon as you send, say, for example, a text message to your recruitment partner and the candidate, if they're using a not so good plan, doesn't see it. So they end up sending a message back saying, can you please change over to WhatsApp? Because that's the only way they communicate, WhatsApp and text. And so in order for them to group text, they need to use WhatsApp. So, you can have policies saying we only communicate using these platforms, or you can have security and policies that allow you to use multiple platforms, but full disclosure, written policies, clear definitions, understanding how those can be worked, and that will keep everybody out of trouble. And particularly with respect to social media, allow to avoid the unintended consequences where maybe people's privacy, because they didn't know, I didn't know if I posted that, you could see that, so we want to make sure that we do our best in education, documentation, and policy. Principle number 10, we will recognize and respect the rights and privileges of competitors in the true fashion of individual initiative and free enterprise, and we will refrain from engaging in acts of unfair competition. So what do we mean by unfair competition? Let's take a look at a couple of those things. So discussing prices and business terms with competitors during a bid process is often referred to as price fixing or fixing. And so having those kind of discussions with your competitors would generally be perceived to be not only illegal, but inappropriate. Recruiting from a competitor for access to confidential information. So hiring recruiters or candidates or temporary workers or contract workers so that they can come and work for you and then disclose to you all of their corporate secrets would be inappropriate. So when we hire people, we always get them to sign these non-competition agreements are illegal in Ontario now, but we have confidentiality agreements and non-solicitation agreements. Those are legal. And so having a person come to work for you for the primary purpose of knowing who their customers are and what prices they charge and what their markups are and what the dominant buying and selling criteria are for that particular contract or arrangement, these are all inappropriate behaviors. So not only should we not want to, when we hire an employee, we restrict them from some certain types of behavior when they leave or even when they're still working for us. We also want to sort of turn it around and say, when we hire people, we want them to honor the same types of behaviors with us that we would expect our employees to stand up to in terms of conduct if they went to work for somebody else. So if it's inappropriate or unfair for my employee to leave and go and disclose my secrets to the competitor, then it would be inappropriate to hire the competitor's employees. It's not inappropriate to hire the employees, but it's inappropriate to hire the employees and then expect them to or try to get them to provide you with confidential information that they received while working there. Knowingly multiple submit a candidate. So the reason why we ask our candidates, can we submit your resume to this place, is because they may have already submitted their resume. And if they say, no, I've already submitted my resume to that place, please don't send it, and you knowingly submit it anyways, you're just setting yourself up for this right to referral conflict, potentially causing harm to not only your company's reputation for attempting to collect money that is not due to you, but also you might cause harm to the person's chances of getting the job. I've seen it before where employers say, we're just not going to hire that candidate because there's two agencies that want to get paid on the fee, and I don't want to get into a fight with them. I don't want to have a lawsuit. So screw it. Let's hire the second candidate. So knowingly multiple submit a candidate. The the adhering to legislative requirements and contract terms, abusive market dominance is typically when we talk about competition laws, and you get into particularly federal laws, big, huge companies that dominate markets, and then they want to buy or merge, with other companies that are the other only dominant market company. Then the Competitions Act, I think they changed the name of it, comes into play, and then you have got the government telling you whether or not they'll approve that or not. But the whole reason behind this is that we don't use our market dominance to fix prices, to establish unfair or inappropriate market rates, pay rates, union pay rates, job category pay rates. And we see this happen all the time. Everything from bread companies to employers of pilots. And it never goes well. Okay, this is a silly question, but it's a question. So you have a candidate walk in, spend a few minutes with them, and you understand what type of work they're looking for. You find that the person does not have the skills that you are currently recruiting for, maybe not even in your area of expertise, but you are aware that in the market includes your competitor specializations. So you know that the competitor down the road or down the street or downstairs, or your friend who works somewhere else, does hire and does need those people. Is it appropriate before you leave? Would you consider saying to them, thank you for coming in today? We'll keep your resume on file and contact you when we're recruiting that skill set. Basically saying thanks, but no thanks, nothing here. But we're going to make you feel good. Would you say thanks for coming in to see us today? Although we're not recruiting for that skill set, please continue to look at our website and job opportunities. Here's my card. Feel free to contact me in a couple of months to check in. That one says, you know what, we're not really recruiting for you, but we might someday. But I'm going to put the responsibility a little bit on you too, to kind of take a look and see whether or not we're in your space or not. And the third one is, thank you for coming in today. Unfortunately, we're not recruiting your skill set. Here's my card with our company website. I recommend you check our site for new postings on a regular basis. But I also noticed that ABC Recruitment Company downstairs across the road around the just did a job posting today, and it fits nicely into your skills. There's absolutely nothing wrong with number C. If you're not going to be of assistance to that candidate, but you've got something that you in a direction you can send them, I'm not talking about giving people unsolicited advice. That's different. But saying, hey, you know what, we don't ever really hire professional skilled trades. That's not in our thing. But this guy's an ACSESS member, and he hires skilled trades. That's all he does, or she does. That's all they do. Why don't you give a call over to that company? They might be more appropriate for you. That's perfectly fine. It's perfectly fine to do that. But I think maybe we'll keep your resume on file. If you have no intentions of ever hiring that person again, it's probably okay. But you might want to just let them know, don't keep calling me all the time, because I don't think I'm ever going to have that kind of job. Thanks very much for stopping by. We're currently not recruiting for your skill set. I wish you the best of luck in your search for employment. So that's the non-answer answer. Okay, next one, principle number 11. We will ensure that our clients, candidates, employees are aware of our duty to abide by the code of ethics and standards and such supporting policies and guidelines as may be from time to time be adopted by the association, will undertake to bring any potential infringements before the appropriate association body. So I talked earlier, right near the beginning of the presentation today, that ACSESS member companies are required to post the ACSESS Code of Ethics and Standards someplace in their membership, someplace visible so that everybody knows you're an ACSESS member company. But also when another ACSESS member is knowingly, obviously in violation or infringement of association policies, we've got an obligation to inform somebody. And, you know, you could, if it's your friend, you could potentially say, hey, you know that I saw an ad you had in the paper the other day, and, you know, it just jumped out at me right away because of the age thing in there. You know, you might want to go back and review a couple of those ads. And they might go, geez, thanks for telling me. They might say, screw you. Leave me alone. It's none of your business. So taking some action, there is a process that we have for informing the association of unethical behavior. I think we go into more detail in a couple screens, but I'll quickly cover it just in case. I can't remember exactly where it is in the presentation. You know, if you do know of a ongoing systemic violation of ethics by a member company, you can contact ACSESS unofficially and make the executive director aware of your concern. The executive director at that point in time can take it into her own, in this case, Mary, can take it into her own hands and say, okay, leave it with me for a couple days. And she can look at it. If it's something in the public domain, like on their website or in their job postings, then, you know, she can contact them and say, hey guys, we just want to let you know we got a concern about this. And 99% of the time, the company goes, oh my goodness, I didn't know. And they fix it 99% of the time. In rare instances, the company doesn't respond or doesn't respond appropriately, in which case we ask the member company who brought it to our attention to put something in writing. They don't have to go into a ton of detail. They don't have to be vindictive. They don't have to recommend, they shouldn't recommend what an outcome should be. They should just say, it's come to our attention that this particular company, here's 4 examples of the ads, and they persistently are recruiting for people violating human rights, or that where they've got a copy of an employment contract that specifically has illegal clauses in it, charging fees to candidates, or whatever the complaint might be. And then ACSESS executive director takes it to an ethics committee, which is a subcommittee of the board of directors that is obliged to maintain confidentiality. And so with as little information as possible about names, the circumstances are brought to the attention of the committee, and the committee makes a recommendation to the executive director on a course of action. And then I can assure you that with the exception of one circumstance, which I'll bring to your attention, over the last 30 years, 100% of the companies that have been addressed, and they're not very often it happens. And when it does occasionally happen, like, I mean, once every several years, the companies have been 100% compliant. They have said they were unaware, or maybe they disagreed in their interpretation, and then they were properly informed and they modified their behavior to be in conformance with the legislation, regulations, and the ACSESS Code of Ethics. In one particular case, there was one company that was in a temporary staffing business that also, I'm going to say, was sort of like in a acquisition mode. They were merging together temporary companies and providing services and, you know, doing stuff. And it was perceived that that company was using its reputation and its connections through ACSESS in order to acquire companies. And I got to tell you, every company in my understanding that ever said, boy, that sounds like a good idea and did it, they didn't regret it. But even though the outcome was good, it was the perception was that this company was using their membership and access in order to solicit the business in a different kind of way, not recruiting employees, from the competition. And so that particular company eventually left ACSESS just because of the ongoing question as to whether or not they should or should not be a member and allowed to do what they do as a member. So there's been one situation in 30 years that was resolved through the process, and it wasn't necessarily even a code of ethics violation, but it had the perception of being one. And 100% of all the others have been resolved entirely to our satisfaction. So it's a good process. It's a secure process. It's a confidential process. So case study, hiring manager for Fish Inc. is looking for 4 people to work at the welcome table at an upcoming conference. The conference is expecting about 1,000 attendees, and they'll need 4 people to work at the check-in desk to provide swag bags and register employees or attendees and all that kind of stuff. The conference is about companies promoting ocean things and themes, from geography and ocean currents to equipment and safety and environmental impact. And the welcome table greeters will need to wear a uniform of a white blouse and a black shirt. Well, normally we would do a role play on how the recruiter would take this order, but we all know that when you say blouse and skirt, you're saying we're looking for female hosts, customer service representatives, and you know, an open discussion with the customer about saying, okay, so we're going to be wearing white tops and black bottoms. Are we looking at collared and buttoned shirts? Yes. Shirts and blouses? Yes. And we can look at black skirts and black trousers. Is that okay? Yeah. And nothing is tight, like yoga pants, that they're all dress pants or something similar. Yes. You know, so if we send some men in there, then they're fine with the white shirts and black pants. Yes. If we have women who prefer to wear pants other than a skirt, are you okay with that? Of course we are, but you know, we just want everybody to look the same. So having a conversation about having the uniformity of the uniformity of a uniform is good, and maybe not even need to be discussed. That you just refer men and women, and the men wear black pants and the women wear black pants or black skirts. Maybe not even need to be discussed, but generally a lack of communication is the cause of most problems, and communication is usually the source of resolution to most problems. And you know, there's a stupid expression that says kill the monster while it's a baby, which means deal with it before it becomes a problem. So good communication around this in a role play would probably be a pretty good role play. So abiding by the code of ethics. So wrapping up part 1, specifically, these are the things that we could do. We could audit our internal documents and our practices. We could review all of our service agreements and documents and employment agreements and procedures and business practices to make sure that they abide by the code of ethics and standards. Keeping in mind also things like, you know, I had a customer, I think, you know, I'm in the consulting business. I had a customer in a different industry, in the steel industry, who was dealing with some retirements actually, and you know, how much notice the employee should be giving, and they had some stock option plans, and it was complicated. And you know, it came to our attention that all of the senior employees and salespeople in this organization have non-competition clauses in their employment agreements, which became illegal in around 2018 in Ontario. The Ontario government said, hey, look, it's what you really want to do is protect confidential information. So define confidential information and protect it. You want to have non-solicitation. You don't want them to use the information that they gained while working from you to solicit your customer and your employees. So have non-solicitation agreements. But these non-competition things, which were a blanket that you would throw over to just stop people from competing because you didn't want them to use confidential information or solicit, but that's a lot of paragraphs. So let's just say you're not allowed to work in the industry within 25 miles or 100 miles. The government came and said, that's too restrictive. Let's not do that and allow that anymore. Well, it turned out that this particular customer of mine has been a customer of mine for years. Never dawned on me that they wouldn't modify their agreements. So, they got to go back to all, because their employment agreements, having that clause and not having a severability clause could make the entire employment agreement null and void because they've got clauses in it that are illegal. So we want to make sure that we have people re-sign new employment agreements. So review all your employment agreements, not just because they might not be right, but because some things might have changed or been outdated. Create templates for your job postings so that they wrap up properly and people don't have the opportunity to unwittingly or unknowingly put wording in it that could be harmful or inappropriate. Provide thorough training to your employees to ensure awareness of all their legal and professional expectations. So the things that you're learning here today, if you think that they're pervasive across your company, then you can take the things you've learned in the last two legal sections in this section and set up some lunch and learns inside your own company and start to really kind of drill down on some of the stuff. Promote a culture that influences the treatment of all candidates and employees. So, it's not just right to have a rule. It's more important and just as important, more important to have a culture that says these things are important to us. They're important to what we think, what we believe, not just that they're the rule to stop us from getting sued, but these are the things that we think and we believe. So promote culture that influences the treatment of all candidates and customers appropriately. Creation of a code of ethics of operating guidelines and ensure, you can have the ACSESS code of ethics and you can have your own code of ethics and standards. And it's not uncommon in companies' strategic planning sessions for them to say, here's our values. And they sit down for an entire day and the employees talk about what are the 5 or 10 core values of our company about being honest to our customers or treating our employees with respect or collaborating and cooperating for the best interest of people or doing things in the most efficient way. There are all kinds of things that you can put into a culture document that can come through some strategic planning, business planning, and forward-seeking kind of programs, initiatives inside your company. Post the code of ethics and operating guidelines. They're available on the website. So I think that the next screen, maybe not. So, sorry guys, that phone wasn't turned off either. You can go into as a member with your login onto the ACSESS website, and you can look for copies of all the business practices and operating guidelines that we're going to talk about in the next 45 minutes. So operating guidelines. Some of the operating guidelines are things like, and I'm going to talk about these in more detail. Workforce transition guidelines. That's when somebody's got a contract with a bunch of temps or contractors there. The contract comes to an end. It goes to a tender, and a new company gets the contract. What happens to all the workers who are there? That's workforce transfer guidelines. Providing service during a labor dispute. So you've got a customer that goes out on strike. Managers are still coming to work at the facility, and they're trying to do the work to keep the operation operating. And then they've got picket lines out front. What are our obligations, particularly if we've got temps working there, we're not in the union, or if even more difficult situation, the customer calls us and says, hey, we need some temps to help cover these people who are out on strike. We'll talk about that. Headhunting for staffing professionals. So we talked a little bit about that already. Compliance with the Competition Act. I talked a little bit about that. We'll go into more detail. Assignment completion dates. We talked about that. We're going to drill into that a little bit more detail. And the hazardous material and workplace issues with respect to the staffing company being the employer of record, but not having control over the hazardous materials on the customer site. So we'll address that a little bit. And we've already talked about the discriminatory order response. There's stuff on the website about that. We won't go back into that because I've brought it up 3 times already today. And a little bit about application forms is also on the ACSESS website. So if you go into the ACSESS website and log in as a user and you go to the member services area, you're going to see a bunch of highlighted hyperlinks that allow you to go to these topics about, for example, how to define the employer of record. What's the definition? What are some of the guidelines around application forms? What is the industry's association's policy on workforce transfer guidelines? So these things are all available to you. We're going to discuss them a little bit here. So in scenario number 1, with respect to a workforce transfer, you've been the sole supplier to Thompson Tire, which is a provincial chain, and it's now looking to expand across the rest of the country. And they've chosen another company to be their master vendor for their recruitment program, whether it's temp or perm. Your company's invited to respond to the RFP process, but you're a local company and you're not a national company, and so they're going to select 3 top vendors to help them nationally. But you don't win a spot because you're a local company. So you've been asked to work with the master service provider, the MSP, to conduct a workforce transfer of all your existing employees. So in other words, they want to hire all of your temps and contractors. So you're not happy with the outcome. You have over 60 workers there, and you've taken a lot of time and money to recruit those people for your client. You put a lot of effort into it. They're your resources. You worked really hard to assign these employees. So you immediately get to phone them to inform them that you're no longer have the business. Look, I always say I'm going to change this. Dusty Donuts and Thompson Tire. It's not Dusty Donuts, it's Thompson Tire. You plan an early morning meeting on site with the workers and coach them to end their assignment in a week's time, and you're going to place them someplace else with another customer. So thinking of ACSESS specific guidelines when transitioning assignments, how would you rewrite the last paragraph? Give a high-level overview of your workplace transfer policies. So the first 2 paragraphs describe a common situation as to why a workforce transfer might be requested or required. And if we go and take a look at the workforce transfer policy guidelines, what we learn or are told is that our first obligation is to be open and transparent. So we need to inform our employees that our contract with Thompson Tire is going to end and when it's going to end. At that point in time, we've got an obligation to inform, or we should inform the workers that they're going to have an opportunity to make some choices, and that the other companies, either the customer or the RFP winners, the MSPs, will potentially be offering employment or something to them. It's not for us to say what it is or whether they should or they should not take it. If you've got other work for those employees, they're your employees, and your customer ended the contract. So you can say to them, I've got other work for you, and it kind of looks like this. You are going to have the option to accept the continued work with us or to accept whatever is offered to you through the other people. You're not obligated to provide the resumes and the downloads and the email addresses and phone numbers and social insurance numbers and payroll data to anybody. As a matter of fact, that would be a violation of privacy laws. It may very well be that your circumstances are such that you think that this is done and gone. There's nothing I can do about it. The customer has got a temp to perm agreement with me, and everybody's been there for longer than 6 months, and it's in Ontario and I'm not allowed to charge a fee anyways. So I can't sue anybody. I can't charge anybody. If the customer hires my temporary workers directly, they're fully within their right to do that. So I either got to find these people other jobs and or make promises to them, or they're going to accept the other job, or I just don't have another job for them. And if I don't help, this is just going to cause aggravation for everybody. It's just going to potentially cause people to become unemployed, to miss the opportunity for my customer, who I hope to get future business from at some point in time, to become disrupted. And so our goal is to be as open and honest and transparent as possible, giving employees the right to choose and to pursue their own employment without undue influence, no fear of retribution or reprisal from us. And that if we're going to disclose private information, because we think it's in the best interest of the employees and the customers and the incoming company, and then we can seek out written approval from the workers to give them authorization to disclose that information. And or you might, want to aggressively attempt to negotiate to be an ongoing supplier as a sub-supplier to the primary supplier, taking maybe a smaller margin or something in order to keep the employees and keep the business. And so instead of making $10,000 a month in gross profit, you make $6,000 or $5,000 in gross profit, but it allows for those temps to work through the natural end of their assignments. Very often in a workforce transition, everybody understands that sharing of private information is inappropriate. Transferring valuable information that a company's paid a lot of money for to a new supplier so that they can just price it lower and win the contract is inappropriate. So very often we try to negotiate with the customer that they simply allow our workers to work until the natural end of their assignment. So if they're there on a maternity leave or a 1-year contract or a project or 2-week vacation, that they work until the end of their assignment and that their assignment is not renewed, and that we deal with them on a 1-by-1 basis, which might make it easier for you to keep your workforce and to transition them somewhere else than have 60 people all available to you on exactly the same day. So looking at the workforce guidelines will give you some indication as to what the principles are when you're trying to figure out how to deal with this transfer situation. Okay. Next topic is the bona fide referral. So we heard the term bona fide occupational requirements. This is now a bona fide referral. So that means a real, tangible, credible referral. So when there's a company there's 2 ways that a bona fide referral may come in question as to its bona fide, which is, 1, did you have the authorization to represent that candidate in the first place? Like when you sent the resume in there, did they say, yeah, you can represent me? And did you participate in the process to take them from resume to job offer? Or number 2, were there, and so the company might say, yeah, we already have that candidate. Thank you very much. You're done. We'll take it from here. They applied to us directly a month ago. And if you don't take it from there, if you don't follow through on being responsible for the matching and the negotiation of the employment agreement, it's probably not bona fide. And the second situation is when 2 companies have presented the same candidate, and oh my goodness, like it can get complicated. You could have I don't understand candidates, but I do, their own greed and selfishness and fear and misunderstanding. But they could have 2 companies, 1 bank, and 2 departments, and the same candidate is being represented by 2 employment agencies to 2 similar but not same jobs under 2 different hiring managers. maybe in two different entire parts of the bank, have nothing to do with each other. And then all of a sudden one of the employees gets a job and the other one says, what? You got a job at ABC Bank? I was presenting you at ABC Bank. And then that company tries to collect a fee also. So we've got a situation where, number one, did it meet the requirements at all? And then number two is, if it did meet the requirements at all, and there are two companies, which of the companies is entitled to collect the fee? When a staffing company confirms via email or telephone that they're going to be sending a candidate over to them within the next 48 hours. Well, that's doesn't meet the requirements of a bona fide placement. Yet the customer agrees to accept the introduction of the candidates and their resumes from the staffing service. So the customer says, yeah, okay, send me the resumes, and you send the resumes. Starting to get there. You've got approval from the candidate, you got approval from the customer, you got the job order, you sent the candidate. Starting to get there. The staffing service informs the candidate of the name and location of the employer, including the name of the individual to whom the candidate will report to for an interview. So we're starting to put together all the pieces for the hiring process. We're getting there. When the customer is informed of the candidate's name and qualifications, or a resume has been sent to the employer and evidence of the timing of receipt has been satisfied. Basically, all of the above of these things, we need to confirm a job order and that we're going to send candidates. We need to have the customer say, yeah, please send me the candidates. The staffing service has to inform the candidate of the name and the location of the customer and get authorization to submit it. That's part of the process. It has to be sent over to the customer, and the customer says, got it. This doesn't conflict with anything. This all starts to set the stage for a bona fide placement referral. Of course, you'd like to have a service agreement. The terms, some people call it a term sheet, but it's an agreement saying, I agree to give you the job orders and you agree, and I agree to pay you if you send me the candidates that I hire. And it's got a lot of details in the term sheet or the service agreement or the recruitment agreement. There's lots of them that have got things saying, we're going to confirm with you within 24 hours whether or not we already have that candidate on file. There's all kinds of things that you can do in writing to help make it even better. And then, of course, if you're involved in negotiating the offer of employment, these things all make it more bona fide. And so very often the question is, if there's two agencies, which of the two agencies had a direct nexus from the presentation of the resume to the acceptance of the job? And the fact that there might have been some parallel action going over here that doesn't meet all of the requirements and really has no direct nexus to the job is the one that gets moved out. It's almost unheard of that you would have the same candidate going through the same hiring manager for the same job through two separate agencies, and the candidate doesn't say, hey, wait a minute, something's going on here. So usually there's one with a direct nexus and one with a somewhat indirect nexus. And until they understand, they just think, oh my goodness, I think the customer stole my candidate. And when really that's not what happened. Who's entitled to the fee when two separate agency services submit a candidate to the same employer for the same job, the same day, within the same hour? Well, it's basically usually the first one, but it's more likely to be the one that, if within that very short period of time, the one that's told yours is a good resume, we're going to accept, and the other company saying yours is not, we're not going to accept. And most companies have rules about that, even to the minute or the hour. So they get time stamped when they're received, and the process begins with the company that provided the resume first. If you did not know what action to take to a situation, where would you go to find the answer? Well, the answer is to the ACSESS website, and take a look and see if there's a policy guideline there. How can you, as a recruiter, staff, and coordinators, prevent sticky situations like these from occurring? Have contracts and agreements and communicate and confirm things in writing and put them in emails. This is how you avoid that stuff from happening. Scenario number 2, employer of record, the customer call me okay, so I'm going to start to move more quickly, but this one basically, I think this one is the Christmas party. And the company is having a Christmas party. Some of the temps are going to be invited. So yeah, you've received 3 calls this week from your temporary employees, very concerned and angry, asking why they did not get a gift card when they were at the holiday party last week. And so, you know, a lot of situations, the customer treats the temporary workers and the full-time workers pretty indiscernible. You know, like they're all part of the same team, part of the same pool. But then when it comes along to things like benefits and something as simple as gift cards being given out at a Christmas party, I'll give an example. I've got a customer that's got about 120 employees in it right now, and they didn't have a Christmas party last year. They're going to have a summer in June or summer in July, Christmas in July party. And this last Friday, the customer said, how much money are you going to give us to put towards this party? These are the things we want to do. Our estimated budget is, I can't remember what it was, you know, $3,000 or something like that. We're willing to put it on our site to do this and do that, but we need gifts from you, and you pay for, you know, finger foods and, you know, whatever. And so they're basically saying they'll organize it, but we're going to pay for it, you know, is the approach that they're taking, and we agree. And we agree that we should probably be more involved in the organizing part too, because they're our employees. They're all our employees. So, you know, we want to ask questions like, for example, on this thing, why didn't I get my gift cards? First question is, did you know anything about the party in the first place? Did you know it was going to happen? And if you knew about it happen, did have you spoken to the customer within a certain period of time about what's going to happen at the party? What are you doing? What are people getting? Are you just assuming that everything's going well? No good news is good news, they say. Well, it's not true in the staffing business. Communication and lack of communication is the source of all problems, and the improved communication and regular communication is the source of all resolutions. So, you know, having a customer where everything seems to be going well, so we don't talk to them, lends the opportunity for little things like this to happen, and then for them to become some real serious problems that can arise from employer of record and ethics. So when we're talking about employer of record, we talked about this before, and I'm just going to go through it with you in some detail about some of the standards that exist in multiple areas. So there's decisions that have been made in courts about, is this person eligible employee to participate in the union? Is this person an eligible employee to be participating in this workplace health and safety legislation? Is this employee, they were injured at work, whose workers' compensation plan does it go under? This employee has been denied the opportunity to benefits, but they've been working here at IBM for 7 years as an IT professional. Should they have access to the benefits and are they treated as an employee? The list goes on and on and on. Some of it is regulatory, some of it is in legislation, some of it is in common law, some of it is in some tribunals like workplace health and safety tribunals, but they all fall back upon the same criteria for the determination of the employer of record and whether or not an employee-employer relationship exists. Having said that, some legislation, like in Ontario, the legislation says we don't care. They're the employee of the staffing company. All these things may or may not be confused, and some people might do this and some people might do that. We recognize this, but we're just going to decide up front for everybody the same. If you're a temp going to work for a customer, your employer is the staffing company, and we're going to hold them responsible for everything of an employer, which doesn't relieve the customer from some obligations like a safe workplace, but they're not the first point with respect to the violations of employment laws. Keeping in mind, the government also said we're going to have joint and several responsibility, which means that if we go after the employer and they can't comply because they went out of business or bankrupt, then we're going to come after the customer anyways. So in some cases, like in Ontario, it's written right into the legislation. But in most cases, it's these things. Does the employer provide site-specific safety training? Not generic stuff, site specific. Here's what goes on in this place. Who determines what the pay rates are going to be? Does the customer say to the agency, pay everybody $20 an hour, we'll pay you 30? Or does the agency determine what the pay rates are going to be and then negotiate the bill rate with the customer? Coach and counsel employees. So something's going on with employees, about their improved performance, about their absenteeism, about whatever. Who's taking responsibility for direction, control, and supervision of the employees? So the words coach and counsel are actually direction, control, and supervision is the other phrase that is used in law. Who manages the workers' compensation account, pays the money, recognizes them as an employee? Who administers the general safety training, safety policies, and safety groups or safety committees inside the organization? Who provides the employees any kind of perks that they receive? Who supervise the employees? This is the part of the direction, control, and supervision, which kind of blends together with coach, counsel, employees up above. Who determines the length of the assignment? Does the customer determine that it's going to be a year, 2 years when it starts and when it finishes? I have one company that I counsel, that I provide consulting services to, that has a very special project. They take people from Ontario and they place them in resorts all over Canada, and they work for 3 months. They're allowed to do 2 concurrent 3-month jobs in a resort or hotel like Banff Springs Hotel. And each of those 2 concurrent jobs need to be separate jobs. So you can be a ski lift operator on, for the first 3 months, and you can work in the kitchen for the second 3 months. Then they move. So the employment arrangement that this company has is to provide opportunity to recent graduates to experience Canada by working in places. They determine the pay rate. They determine the length of the assignment, not the customer. The customer has got some responsibility with direction, control, supervision, and counseling, but a lot of the things are provided specifically by the staffing company, which means that the law in Ontario about it always being the agency, in that particular case, their policies, practices, and procedures are aligning with the laws. So who has the right to hire and fire the people? So as we said the other day, a customer has the right to end an assignment, but they don't have the right to fire the worker. Just because they ended an assignment, they say, I don't want that worker anymore, doesn't mean they're no longer employed by the agency. So these are the standards that are often used in determining the employer of record. And sometimes, by the way, when there's a contract that exists between a person and a company, and it, say, for example, says you're an independent contractor, well, first off, you can't do that in Ontario unless it fits into that very special category I told you about, that's high-paid business consultants and IT representatives. So first off, you can't treat an administrative person making $20 an hour an independent contractor in Ontario. You could in Alberta, if what happens is the contract that you have with the administrative person who's acting as an independent contractor actually matches the real life circumstances that exist. So does that person really have the right to hire and fire their own employees? Do they really have the right to set up their own schedule? Do they really have the right to determine how they're going to perform their work? Because these are all definitions of an independent contractor. And so if the contract says this, but reality says that, then the courts will always abide by that. They'll say you can't write a contract that misclassifies the reality, then treat persons in reality this way and think that you can get away with the contract, which is avoiding your responsibilities as an employer. So the courts will always fall in favor of the reality over the paperwork. Although when the paperwork and reality align, the paperwork provides more credibility to the story about reality and determination of whether a person is employee or not. In scenario number 3, it's expected that the staffing service firm is retaining temporary orders, remit appropriate source deductions. If you are supplying independent contractors in temporary employee roles to have cost savings, you may end up having a short-term gain, but liable for long run for more if it's not complying with the law and paying. So what they're basically saying is, if you misclassify somebody and you don't pay unemployment insurance, Canada Pension Plan, workers' compensation, you don't remit it, withhold it from their taxes, you don't pay employer's health tax, you don't pay vacation pay, public holiday pay, you could find yourself 5 years later being audited, taken to court, and having to pay 5 years worth of vacation pay, public holiday pay, unemployment insurance, Canada Pension Plan, workers' compensation premiums, and employer's health tax. The only saving grace, if there is one, for a company that made a mistake, I'm not talking about a company that did it intentionally, companies that intentionally do things wrong or doing things wrong, but just say, for example, you made a mistake, it's not likely that different levels of government, like for example, the employer's health tax branch and the federal government, CRA, around unemployment insurance, Canada Pension Plan, and tax withholding, would gang up together. It would be your obligation if CRA determined that they were employees that you inform the provincial government, but sometimes they would be separate actions. Okay, we're getting into the final stretch here. We've got 15 more minutes to go. So, we want to manage our business. We want to make sure that we're dealing with our guidelines and knowing that those guidelines exist on the website in the members only area. Yeah, so, doing things wrong. I've given you lots of examples. You could be fined, could be found to make back payments, could be sued, all kinds of things. This one, Denny's restaurant, not going to spend a lot of time on it because it's probably not something that you're going to find yourself into, but it was the first class action suit. I think it occurred in Alberta, and under it was the temporary foreign worker program. The lawyers succeeded in getting a class action certification settlement for $1.4 million on behalf of the foreign workers. And what happened was, first off, it was the first class action suit involving temporary workers. And these ones happen to be temporary foreign workers. So it gets complicated because there's things like housing and security and things like that that are involved in the temporary foreign worker program. The workers alleged that they paid thousands of dollars in recruitment fees to an agency, but Denny failed to provide the amount of promised work and failed to pay the overtime or reimbursement for travel. So these people are paying lots of money to the agent, and then Denny doesn't come through with enough work to make it worth their while. They allege breach of contract, breach of fiduciary duty, and unjust enrichment. The workers maintained that Denny's was also trying to intimidate them from participating in the class action lawsuit. This led the court to order that there would be no repercussions whatsoever because of their participation in the action. And in fact, those people that had pulled out of the action were told that even though you pulled out, you're going to be included. So, you got afraid, you pulled out. Don't worry. If we come to a conclusion in your favor, you get included too. So that's kind of like, we all decided to buy lottery tickets together. And then one day I started to get afraid that you were taking my lottery money and not buying tickets. And so I pulled out. And then the courts got involved and said, no. If they win, don't worry. You're going to get part of the share too, because these guys were in fact treating you unfairly. Appropriately, 1/4 of the employees opted out of the lawsuit, and raising the question as to whether they did so out of fear of retribution, or maybe even hope that they might receive support from Denny's and be treated special because they opted out. The court noted that temporary foreign workers were particularly vulnerable, and an opt-out employee were included in the settlement. So that's what I just described to you. Those promised 37 to 40 hours per week were paid for any shortfall in their hours. So if they were recruited from a different country and told you're going to work a full-time job and only work part-time, they were given the money to make up the difference between part-time and full-time. They were reimbursed for their airfare to Canada. They were reimbursed for the agency fees that they paid to the agency, and Denny's donated a whole bunch of money to a migration fund. So, you know, the repercussions of dealing with unethical agencies for Denny's was really high, and the agency probably, I don't know, the agency was probably off out of country, so they got away scot-free. The licensing agreement in Ontario that is now coming in play, and those licenses in Quebec and Alberta, British Columbia that already exist, are meant to protect workers against that kind of stuff. So we talked about managing unethical behavior from our clients. So sometimes we see our clients do things like discriminate against workers in their selection or treatment of their workers. They can breach their confidentiality by, say, for example, providing information on references or information to people about the temps that work there. The clients can refuse to pay their fees and breach their payment terms, and they can also enter into multiple recruitment agreements and not tell the agencies that they've got 3 agencies working on exactly the same jobs, causing some potential down the road. They sometimes try, even though the law says they're our employees, they sometimes try to treat our employees like they're their employees, creating a lot of confusion. And they sometimes take a really aggressive position on that. And that is unethical and inappropriate. And sometimes they are have some kind of screening, like, say, for example, financial credit check screening for jobs and so on that are not even relevant to the job. And then the final thing is that whole thing about workforce, for final example here, workforce transfer. So they go out and they take a new contract with a new supplier, and they start to supply all of the information they have about the temporary workers to the new supplier without anybody's approval. So it's important that when we're trying to manage the behavior of our customers, that particularly when there's a workforce transfer, that we get in there really early, even during the tender process, saying, okay, guys, well, we're going to put this out to tender. Let's get the rules set up front so that everybody understands what it is. When it comes to recruiting unethical recruiters, well, basically, you know, we're just repeating now a lot of the stuff that we already talked about. But as employers and managers, we sometimes have people who work for us who don't follow our policies or who are unaware of what the appropriate behavior is. So they could potentially be accepting discriminatory job orders. They could potentially be using personal information of our candidates and our customers in a manner which is not intended. They could lack concern for health and safety by sending temps into warehouses or factories that are not safe workplaces, and they are not doing their due diligence to go and visit those workplaces and to verify that the customers are going through the appropriate process for standards, safety standards. They could breach any form of a customer client contract agreement by maybe, you know, recruiting a candidate out of there, or, you know, who knows. They could, more confidentiality. You could have somebody's working on straight commission, feel like they have motivation to misrepresent a candidate to your client so they can get the placement and the placement fee. It's our job as owners and managers to set the standards and expectations with respect to the placements that they make. They could be recruiting from your clients so that anti-rating clauses or agreements need to be enforced. And they also could be acting in some way that made employees feel as though they were not able to make their own choice, but whether they should accept the job from the customer if the customer offered to them or something like that. These are now basically the same things that we talked about: recruiting from our customers, using our ACSESS membership, charging fees to candidates, being deceitful with candidates and clients, so on. So the solution to this is preparation. That we do our research in advance. We know companies, our own policies. We know our customers' policies. We know what our training plans are. We know what our customers' training plans are, and that we create documentation around that so that there's clarity with respect to expectations. And then we create awareness in terms of training of everyone so that everyone is aware of what we found out, the research portion, who does what we documented is what the plan and process is going to be. And then we train them, creating awareness so that people are all adhering to the standard policies, practices, and procedures. Candidates, my goodness, you've been there before. We're not going to spend a lot of time on this, but candidates, you know, they can lie to you about misrepresent their skills, their credentials, their experience. Never happened before. They could misrepresent the salary or the income that they're making in their previous employment. They could be using you as a recruiter to leverage counter offers from their current employer to get you to, you know, start sending them out for interviews and start having discussions. And they go back to their bosses and say, well, you know, the other guy is going to offer me $10,000 more. You know, they could use you or participate in a process, then just ghost you and, you know, or fail to follow through on their commitments and circumstances and cause harm to your reputation. They could circumvent you. They could find out who the agency person is and go around you and maybe try to figure out how they might think that they've got a better chance of getting the job if they cut you out. They can provide false references, like the leather treaty case that I talked to you about before, where the person had a previous criminal record. So we won't do that poll. I talked to you already about the ACSESS complaint process. In our last 6 minutes, I'm going to give you a little bonus area that is not part of your exam, but everybody should know. Let me see if I go 1 2 minutes. Okay, I think that's it. So most agreements with customers cover something about insurance. And most service agreements with customers, particularly those written by the customers that they give to you. So typically a government will write the customer the agreement and they'll give it to you and you have to sign it. Or a large corporation will write the agreement and give it to you. And then as you kind of get into smaller organizations, you write the agreement and give it to your customer. And of course, the person who writes the agreement and hands it to the person has the most control over what's going to be in that agreement. And so we tend to see these two areas. We see these areas of liability and indemnifications. So the indemnification means I will make sure you're cause no harm due to these kinds of things. So that's indemnifying. And we'll be liable for these kinds of things. So in other words, we're going to be at fault if these kind of things happen. So those are defined in the agreement. And then in another part of the agreement, there's usually a list of the mandatory insurances or the minimum insurance that the supplier has to have in order to qualify to be a supplier. And you would think that there would be this sort of link between indemnifications and potential liabilities, that now you better have insurance to cover these things. But they don't always align. Sometimes the insurance says you got to have all this insurance, but we're only defining this thing as what you're liable for. So you got to have way more insurance for stuff that may never happen. And even if it does happen, it may not be our fault for this stuff that we're liable for in this indemnified and liability section. So on one side of the coin, you want to make sure that there's an alignment. You certainly don't want to have an indemnification and liability section over here and not have enough insurance over there. In other words, we promise you we'll indemnify and hold you harmless, but I don't have insurance to cover that. So you want to at least make sure that it covers it. And then from a business standpoint, you don't want to make obligations to have insurance that you don't need because it's just costly because it didn't exist over here. So there's the two parts. And then they typically talk about the types of insurance that you need to have. And some of these are driven by your contract, and some of these are just driven by your need for insurance. And sometimes your contract is it's just like you're obliged to have this insurance, otherwise you can't win the contract. So it's a business decision. And sometimes there's a real risk. And so you got to have insurance. And they're not always the same there too. Sometimes I'm just doing this to qualify. And although it's never going to come into play. And the other times is, hey, look, I got a building and I got a car, I better have insurance. So that makes sense. So commercial general liability insurance is often called CGL. This is the kind of insurance that I call the Wile E. Coyote insurance. If an anvil happens to fall out of the ceiling and land on somebody's head, then usually the general liability insurance will cover. So they slip and fall on the ice in your building, or something products causes somebody any harm, or something unintended happens and you get sued. Usually the commercial general liability insurance is that covers you. And by the way, there's other things called blanket insurances, which are big insurance policies that insure your insurance policies. So in other words, your insurance policy says this is for 5 million, but we're going to throw an additional blanket over top of that to cover $10 million more of anything that might arise from the first $5 million claim. So that's CGL. The second is property insurance, including fire, water, and theft. There's capital T on theft, but not on fire and water. Fix that. So the property insurance is basically when you own or rent a building and something happens. There's fire, there's flood, somebody breaks in. So typically when you rent an office space or you own a building or own office space, you want to have that. That's the same as your home insurance, except for it's more comprehensive because it's got to cover off how it happened and who's responsible for the water and fire and all that. There's two types of errors and omissions insurance, which are referred to as E&O. And you can be easily fooled because there are several companies out there that offer what I call agency E&O, which basically says that if the agency makes a mistake in the delivery or omission in the delivery of their services, then that's insured. So to give you a crazy example, say, for example, you see resume of Jane and resume of Jane. This resume is an engineer. This resume is a doctor. You go get a job order for a bridge building engineer and you get their names mixed up and you send the doctor to go work to build the bridge, to design the bridge. And the doctor says, wow, I really needed a job. And this is not my area of specialization, but I always wanted to build a bridge. I got a Lego set. Let me go. And so you made a mistake in sending somebody who was unqualified, but it was a legitimate error. It wasn't falsifying documents. You weren't trying to mislead anybody. You sent the wrong Jane, and it was a mistake. So it was an error or omission. So they build the bridge, and the bridge gets built, and they cut the ribbon, and the cars drive across it and falls down. Everybody gets sued. The bridge building company gets sued, the city gets sued, and the agency that sent the engineer to build the bridge gets sued, and the insurance covers because the agency made a legitimate error in the delivery of its services. Now, I've been around this business for a long, long time, and I haven't quite figured out how that inexpensive insurance, not very expensive, how that inexpensive insurance really covers anything that's likely to happen and you're likely to get sued for. Could happen. And I think that maybe over the years, insurance companies have expanded what an error and omission means, but it's still pretty useless insurance. But very often customers say, hey, you have to have E&O insurance in your contract. So you go and spend $1,500 and you buy the E&O insurance, and it's agency insurance, and it really probably doesn't do diddly do for you. Now, if there's an insurance agent on the phone who sells it, they're probably going to argue with me and tell me all the reasons why it's so valuable and why we should all have it. And I admit that there's lots of variations in the E&O insurance. There used to be only 2 companies in all of Canada 20 years ago that offered it. So, they're probably a little bit better nowadays, but that's what I call agency E&O. The contractor's E&O, that's different. That's If you send a contractor to go do something technical or professional in IT or engineering, and the contractor makes a mistake at work, forgets to lock the door, forgets to put the security back on the network before they go home, and somebody breaks into the network and steals everything from all the money from the bank. There's an error. So an error committed by the contractor that we placed while they're performing their work at the customer site, that's more realistic. So that's what I call contractors E&O opposed to agency E&O. Most people don't differentiate between the two. They just say, oh, you need E&O, and they go and buy the cheap one. Cheap one covers little. There's director's liability insurance. This is for owners and directors. This is so that if you create a policy or you fail to create a policy and something bad happens. So an example of that one might be Club Link Corporation, who owns a bunch of golf courses, had some underage or just of age drinkers, a combination of both, who found their way using false identification to drink at a Muskoka golf resort that they owned. The bartender and server didn't realize that they were underage, that some of them were underage, but did realize they had too much to drink, and so took away their keys and said, you guys can't drive. You got to hand over your keys. And they took away their keys. They stopped serving them. They made them call for assistance, and they did whatever they thought they were supposed to do under safe serve rules, except for somebody had an extra set of keys, and they went out to the parking lot, all got into the thing, and they drove off of a bridge into the lake, and some people died. I don't know the whole story. Maybe all of them died, but people died. And it was tragic. And so next thing you know, the Ontario government is saying, oh, should we be changing our drinking laws, and should we be changing our driving laws, and should people that are 17 years old be allowed to drive, and so on and so forth, and allowed to have 3 people in the car. And it created a whole firestorm of issues for people to deal with. And then the families of the children, the young adults, sued Club Link and sued the directors of the corporation for failing to have adequate policies in place. They did have adequate policies in place, and they did have follow those adequate policies, and it's not their fault that the kids, young people, behaved badly and went out of their way to circumvent the rules and had extra sets of keys and so on. But so they didn't succeed in the lawsuit, but it cost Club Link millions of dollars in legal fees, and their directors and liabilities insurance protected the directors from being sued personally. And also it paid for the lawyers to fight that case. So directors and liabilities insurance for the senior level people who make the policies and decisions, or fail to make the policies and decisions. Theft and dishonesty, which is often in Canada called bonding. So when you say, are your employees bonded? That means, yeah, we've got insurance that if our third party theft, if the employee steals from a customer and it's covered by insurance, it's called bonded or bonding. We don't use the term bonding anymore. In the old days, they are employees bonded. That meant, yes, they're eligible for, and we do have insurance to cover if they steal from you, which is different from theft insurance, which is usually attached to the commercial general liability insurance, which is if somebody breaks in and steals the property insurance up the top, steals from the company. You can have other types of professional liability insurance. So things like, do you get sued because you unlawfully dismissed a person, or because there was a sexual harassment claim, or because there was something to do with being an employer of your workers. And there's special insurance for things like, do you hire nurses? Medical malpractice insurance. This one is important. There's automobile insurance. If the company owns an automobile, they have to have automobile insurance. If a company allows its employees to drive their own automobiles, or rental automobiles, or drive a customer's automobile, then you need to have non-owned automobile insurance. So say, for example, your temp goes to work for a customer and they drive the customer's truck. The customer will have automobile insurance covering the fact that that individual is driving the truck. They get into an accident, then everybody gets sued, including the driver and you, the employer of the driver. And so the non-owned automobile insurance covers you because your employee was driving somebody else's vehicle. And then, of course, there's workers' compensation insurance, which is mandatory in all provinces for certain kinds of jobs, most kinds of jobs in our industry. And that stops an employee from having the right to sue their employer if they were injured at work in the normal course of the work. There's exceptions, but not very many. Like if you said, oh, we're all going to go bungee jumping today, and you may not be insured under workers' compensation for that. But if you're driving people to work, from work, if they're hurt at work, this is a standard model for all companies to put money into a pool run by the government to provide the kind of insurance that would be needed and exists, so we don't have a situation like the United States where everybody gets sued for everything every day, all the time, for hundreds of millions of dollars. And those, my friends, are the different types of insurance. As a salesperson, I strongly, they've got this thing called additionally named insured and additionally insured. And so additionally insured means that, say, two companies go together to do something, they both have to be insured under the same policy. Additionally named insured means that the insurance policy is owned and operated by you, but you name the customer who you're providing services to give them a confidence that if something happens, there's an insurance policy there that was for them to call upon. They still have to prove liability and sue you and all that kind of stuff in order to get at that insurance, whereas additionally insured means you're together. So you never have additionally insured with a customer. You have additionally insured if you have two companies collaborating together in a joint venture. But additionally named insured or named insured puts your customer's name on your insurance policy. Joint and several already talked about that. What happens? Divide things up. And indemnifications, I already gave you the definition of that you're protecting people against harm is an indemnification. Those are the things that all salespeople need to know. I think all managers need to know. Every time you have a contract come through the door, you're going to see things about insurance. Don't just sign it, read it. Make sure that you've got the insurance that covers it. And there are companies out there that specialize in our industry. So if you're looking for special insurance and you need a referral, you could always call ACSESS because a lot of them are associate member companies. And that's it for today. I'm over by 10 minutes again. I keep adding stuff and not taking stuff out. I apologize. Any questions for me before we go? Okay, so again, that probably means I put you to sleep and you don't know what to ask because you didn't hear anything, but all good luck to you if that's the case when you go to write your challenge exam. I don't think I'm lined up to be your instructor. Are you guys signed up for a couple more? There's 2 more courses. You guys have dates for that coming up soon? I don't think I'm going to be your instructor there for that. So I'm not going to see you now to the end of your CPC. Thank you very much for participating. Again, I want to remind you that there's a conference coming up in May. Please go to the ACSESS website, take a look at that. They've got a great agenda and speakers all being put together for that. Please feel free to email me at steve.jones@bell.net if you have any questions about today's presentation or presentations before. I wish you all the best of your luck, and I want to congratulate you and thank you for taking the initiative to pursue your CPC. Have a great day, guys. Thank you.
Same to
Bye.
you. Thank